And item number 45 is the CRP 137 of 2019.
Is allowed. Impugn order set aside in question.
Item number,
Obliged, my lord.
item number 46, MSc Appeal 585 of 2019, MSc Appeal 384 of 2019.
MSc Appeal number 585 2019 stands dismissed. MSc Appeal number 384 of 2019 partly allowed.
Obliged.
I beg to mention the listing, my lord, on Friday, my lord, what are matter for review.
Is there any urgency?
It is not,
If not in the first week of May. First week of May.
First
it
week,
is not numbered, that's why.
it is not first week of May,
And date.
5th May.
My lord, I have also a similar prayer on 5th May, my lord, for admission.
When?
On 5th May, my lord.
7th, 5th May.
5th.
Please, your lordship. I beg to mention listing of an item, lordship. It is a matter of urgency, lord. May the matter be listed on Monday,
Monday?
28.
20th.
One case.
Yes, yes.
So I beg to mention item number 30, lordship. In this matter, lordship, if it is in opposition, we will file, lordship. We have to file a reply, lordship, short reply, lordship. It may be come upon 1st of May, lordship.
Item number 30.
3030. Lordship, in this matter, lordship, senior advocate KN Chaudhary is there, lordship. So he requests for fix this matter on 1st or 2nd May, lordship.
What's a consent or whatever?
Yes, higher it
Private
So
something.
private parties are also there.
is. I will inform them, lordship, because they
No,
have.
you first inform them. Thereafter you come.
I think 30.
You first obtain their consent.
Yes, because they have no rule actually, though I will inform them after that.
Consent one.
No, you first obtain
I
their
will inform.
consent
I will inform after some time.
after some time.
Yes.
Okay.
Yes.
Yes.
I beg to mention for listing on admission matter, Miller.
When?
And next week, any date, Miller?
No, first week of May.
On 7th May. 7th May, please.
Prior to 7.
No date.
So,
So 5th May. then. 5th May.
Obliged.
Yes.
Lordship, I beg to mention for listing of 3 content matters, Lordship, for orders.
When?
Lordship, any day?
7, 8, 9. 3 days.
Yeah, please, Lordship. I beg to mention for listing admission matter, Lordship.
When?
5th of May, Lordship. Not 5th, Lordship.
5th of May, not possible.
Or 9th May.
9.
9th.
9. Obliged.
Yes.
Please, Lordship, I beg to mention for listing of 2 content matters and 1 writ matter on first week of May on any date.
13th and 15th.
Much obliged.
Lordship, I beg to mention for listing of the matter regarding Lordship non-payment of suspension benefit. Lordship,
When do you want?
any day?
14th May. 14th May. Sure, so many cases already we have given. 9th May.
May I please, Lordship, prayer for listing, Lordship, for admission, non-payment of salary, Lordship. 28, Lordship.
28, not possible.
30th, 30.
Yes.
Wait, lordship, I recommend, they have to listing lordship for water lordship.
When?
First week of
2nd May.
Yes.
May I please, Lordship? Lordship, I beg to mention WBC number 3493 for listing.
When?
Sorry.
30 April or
Not
first week of May.
First week of May.
First week of May is
Okay, can you get that from me?
on 9th May.
Yes.
9th May.
Lordship, I beg to mention an item for listing. Your Lordship, the urgency is that the petitioner, he has been served with eviction notice from his government quarters. He's a professor at MIT. So there's some urgency.
Eviction.
When? When do you want?
The Lordship, at the earliest, as for the convenience of the court.
30, 30.
Obliged.
Yes.
May I please, as your lordship, my lord, I beg to mention for an urgent listing of a motion matter on Friday, my lord. My lord, what has happened, my lord, a scheme called, my lord, scheme for providing quality education in madrasa institution in the entire state, my lord. Now there is a fund has already been there pending, my lord. Now the government wanted to take back the fund, and as a result, my lord, the salaries of the teachers of the petitioner association institution is now going to be disturbed, my lord. Friday, my lord.
Okay, we'll try as a last item.
My lord. Oblige. My lord, and some other motions are also there, my lord. I am praying for listing on the first week, my lord.
Take it from him.
7th of May, my lord. Motion,
Keta cases, sir? How many cases?
Tinta case,
Three
motion, my lord,
7th, 9th, and 13th. Please.
my lord. Oblige.
For motion, item number 1,
May it pleases your lordship.
Hmm.
This matter, your lordship, MJ Khatinier will be appearing.
Oh,
After some time, your lordship kindly passes on a matter for.
Only
Thank
difficulty
you,
is that, my lord, my difficulty is, well, I will go to the, my lord, Standard Administrative Tribunal.
okay, of course.
One.
item 2,
Briefly, your lordship. Lordship matter involves compassionate appointment of the petitioner.
Yes, Mr. Bora?
Lordship, matter involves compassionate appointment of the petitioner. Similar matters have been disposed of by this honorable court, lordship, in a coordinate bench, lordship. And same has been put under challenge before the division bench, lordship. And that is pending,
Division
lordship.
bench upheld. What is the outcome of that decision?
That has been put under challenge before the honorable division bench, lordship. Matter is pending before the division bench.
Wait, no, dispose of the person.
9 is seconded.
Completion of that. No, no, Mr. Bora, perhaps this rate appeal has already been disposed of. You obtain information and appraise this court after some time.
item 3,
His lordship, my lord, this contempt petition is against willful and non-willful and deliberate violation and non-compliance of the order dated 6/9/2024, passed in WPC numbers 5398 of 2022. My lord, the relevant portion of the order is in page number 21, para 22. My lord, if you may allow, then may I read?
Which is the relevant paragraph?
My lord, in page 21, page number 22, my lord. If you may allow, then may I read? Paragraph 22. My lord, this has been communicated by letter dated 12/9/2024, which is at page number 24.
Okay, let notice go at this instance. Heard miss your good name, please.
P. Devi.
P.
Devi.
Learned counsel for the petitioner. This petition under section 11 and section 12, 11 and 12 of that concept of Protect 1971, dated 30/1, dated 15 of the Constitution of India. is preferred by the petitioner for willful and deliberate violation. And stroke or non-compliance of the order dated 6/9/2024 passed by this court in WPC number 5398 of 2022. There is the petition and the documents placed on record, and also there is the order dated 6/9/2024. Let notice be issued to the contender returnable in 4 weeks. Step it taken by registered post or PD and also by exam process. We can put from the list after 4 weeks.
Much obliged, Lordship.
The number 4,
May I please, your lordship? Senior English Council is English and other courtroom. So pass over for time being, lordship.
five,
Lordship for timing after some time. Your lordship instruction received.
Let her counsel come.
Video list.
item 6,
May I please, your lordships? In this case, my lord, last occasion, Mr. Das took time to take instruction with regard why petitioner has not been allowed to hold a charge of the insert principle of the Hadley School, my lord. What instructions have come?
Your lordship instruction is still awaited, your lordship. Kindly grant us one last chance, your lordship. to obtain instruction.
Heard, Mr.
B. Rahman.
B. Rahman, learned counsel for the petitioner, and Ms. P. does learned standing counsel for the.
It's the
respondent
second,
in
your lordship.
Secondary education department. Mr. Das submits that instructions are still awaited and press for granting her last opportunity. There is accordingly allowed. This is the matter of her. 1 week.
My lord, date may be fixed otherwise.
Okay.
on 9th May.
I'll look.
Item 7,
May I please, your lordships? Lordship, as the petitioner raised for the similar order, lordship. But I have annexed the order, lordship, annexer 13, lordship, page 58, lordship,
Page number?
page number 58. Annexer 13, lordship.
What is the matter?
Lordship.
What is the matter?
Lordship.
What is the issue?
Issue, lordship, the issue was the lordship, whether the dice code is a mandatory requirement or not for the provincialization of the higher secondary school, lordship. That issue is already decided, lordship. Lordship, by the order dated, lordship, 12/4/2023, by WPC number 1353/2022. And the honorable court had decided that the dice code is not a mandatory requirement for the provincialization of higher secondary school, lordship.
Yes, madam, any objection in passing similar order? You have not gone. for the order.
Your lordship, I have no objection, your lordship, because as per the this order, your lordship, the matter has stands disposed of, because your lordship, it has clearly mentioned that dice code of 1009 to 10 shall not insist, your lordship, because clearly written, your lordship. I have no objection pertaining to them.
Okay, we will pass the order.
Lordship.
If you please.
item 8,
Yes, you received the instruction. Oh, when you have not received the salary?
Your
Since
lordship,
when?
since my release, your lordship, release with effect from 15/10. I was purportedly released from 15/10/2024,
Mhm.
but I continued to render my services till the month of January this year. This is indicated. Your lordship will kindly come to page 26 for a moment. Page 26. Your lordship is at page 26.
Yes.
Release order based on the intimation received from principal ATI via email dated so and so 16/10/2024. Sri Nishanta Kumar Bokhista, part-time lecturer, mechanical auto engineering, is attached to Kamrup Polytechnic and drawing remuneration from Assam Textile Institute, is hereby released from his attached duty with effect from 15/10/2024. This letter, my lord, was issued on 18/1 in the month of January when he was finally released. Your lordship will kindly come to page 53. Page
So
50.
this order was communicated to you on 18/1/25.
Yes, the reason being, there's a reason. Your lordship, this order has a reference to an email dated 16/10/2024.
Hmm.
Your lordship, that email is at page 20. That email is at page 20. This was already in the know of the principal of the college and the government on that date itself. To the principal, Kamrup Polytechnic, Bayhata Sariali, Kamrup, sir, I would like to inform you that as per government order from the Higher Education Technical Department, wide e-file number so-and-so, dated 5/10/2024, Sri so-and-so has been appointed as lecturer against the sanctioned vacant post at Assam Textile Institute, but so-and-so, part-time lecturer, mechanical auto engineering, who is currently attached to at Kamrup Polytechnic, Bayhata Sariali, is drawing salary against the sanctioned post of lecturer. The principal has also written to the DTE stating that we need his services. In paragraph number 10, your lordship, my lord, we have submitted that I was given verbal assurances of being paid for the services which I have rendered. In fact, I was allotted duties in the month of January, your lordship. That's a part of the records. Your lordship will kindly come to page 27. Page 27. page 27, my lord. This is the duty. These orders, your lordship, are for invigilation duties to be held in the month of November. My name features in the second last bracket, your lordship, Nisanta Kumar Bokhisto. Page 27. There are various orders which allotted me responsibilities in the college. Page 30. Page 30, your lordship would see in the month of December.
No, in page number 27,
Yes, page number 27, my lord will come to the bracket of the date, which is 3rd of December 2024, Tuesday. Your lordship sees that? And the second last column, the second
Yes.
last row. Tuesday, 3/12/2024.
okay,
If your lordship goes correspondingly to the right, the second last name, Nisanta Kumar Bosista and Pranjit Burman. On the rightmost column.
yes,
Yes. I was allotted duties in the month of November after my purported termination. Then your lordship will kindly come to page 30. Page 30 in serial number 3, Friday, 20/12/2024. In the name of examiner, Nisanta Kumar Bosista. Then page 31, December 2024. My name features under the date 19/12/2024 on the rightmost column, Nisanta Kumar Bokhisto. Then on page 32, 16/12/2024, a committee was formed for conducting a program at high schools of neighboring areas. I was the member secretary. Page 32, second row, December. Page 33. I was engaged as a tabulator for the end semester examinations. My name features as serial number 2. No, that is not in dispute that there was no post against me because that post was already filled up. What I'm claiming now was that my services were utilized, rather exploited.
no, you tell me whether any provision is there for payment of salary against one post to two incumbents.
So, but that I was assured by the government that I was supposed to render my services. Otherwise, they would not have issued my release letter in the month of January with a back date of October. Your lordship will kindly come to the representation that the principal of the college, page 53, my lord, page 53. Page 53.
Yes,
Yes. This is a letter, your lordship, that the principal of the college had written to the director of technical education. These are the intricate, the details which have been stated. My lord will kindly come to the third last paragraph. It may kindly be noted as informed by the principals of Dibrugarh Polytechnic and Assam Textile Institute, the remuneration of so-and-so and Mr. Nisanta Kumar Bokhisto, part-time lecturers, could not be disturbed from Dibrugarh Polytechnic and Assam Textile respectively, as regular lecturers have joined against the post from which they were getting their remuneration. That is already there in the email. In this respect, necessary arrangements may kindly be arranged to adjust the services of Priyanka Talukdar, Nisanta Kumar Bokhisto, and Sanskita Bormon against vacant post of any other institute under the DTE Assam as requested by them by the letter dated 24/10/2024. In view of the above, it is in the know of the government. It was in the know of the principal. It was based on verbal assurances that I was given an assurance that until your absorption under 3F, I was subsequently absorbed in the 3F. That is not in dispute. But I had to render 3 months of services at par with other part-time lecturers without getting a single penny, with the mere assurance that the government will look into my grievances. Now they're saying that the email which is reflected in 1610, that my post was already allotted to somebody. That is not in dispute. My post was allotted. But the college did not have a mechanical auto engineering teacher in the college. I was requested by the principal to render my services. That has to have some.
yes, Mr. Towelder.
Has to have some bona fide.
You have utilized his service,
Yes, Lordship.
you make necessary payment.
Yes,
Lordship,
that is my submission.
notice has not been issued till date, Lordship. I will bring my stand, Lordship, and by way of affidavit. 2 weeks.
Pardon?
By way of affidavit, I'll bring my stand, Lordship. 2 weeks time may be granted, I'll file affidavit to bring out.
No, from these documents, it is established that you have utilized their service.
Yes, it is there.
The
Lordship.
attendance.
And
it is
how
not-
your affidavit will change the position?
It is not correct, but
What
Now-
purpose
now-
will be served by
now-
filing an affidavit?
now he has been Lordship again re-engaged.
No, that's all right.
On the
But
yeah,
for the period for which he has rendered service, you
Yes.
have to pay.
Lordship. But the one condition was there
What
in the
condition?
appointment letter, Lordship, at para 4.
No, we will not go by the appointment letter now. We have utilized their service.
Lordship.
You make necessary payment.
The release order
Which
was
they are
passed on
entitled to.
18th.
Pardon?
The release order was passed on 18th of January with a back date from 16th of October. Your Lordship is aware, your Lordship has seen that. The release order, your Lordship, is at page 26. Very conveniently, the government had released me not from the date of my actual release, but from the month of October last year. 26, my lord. Twenty-six. Your Lordship sees the date is 18/1/2025. That is at the threshold of me being appointed as a 3F appointee. 18/1. That letter is dated 18/1.
You are entitled to salary.
For 3
from
months.
16/10/2020.
From, yes, my lord. Yes, my lord.
Till 16/1/2025.
Yes. 3 months salary, your Lordship. That's my prayer. In fact, if your Lordship sees the last document, page 70. Page 70, your Lordship would see. This is the statement of pay and allowances. That I was paid till September 2024 at the rate of 72,000 per month. That is the limit. And in the month of October till 15/10/2024, I was paid 55,800. And that is the last of the pay which I've received till my release. That is my only prayer, Your Lordship, that I be paid for the services which I rendered. That is what. Okay.
But Mr. And Sarwal, Lordship, Petitioner and also heard Mr. Ayer Pavil. Pardon?
I'd like to point out one thing, Lordship, at page 20. See, this was the communication, Lordship, to the principal from the director.
Yes.
It was of 16 October 2024.
Hmm.
That one person, Lordship Kondorpo Kumar Nath, has been appointed against the sanction post.
Yes.
So, Lordship,
That's
that
all
was,
right, but if that was the position of why you could not communicate
that was
the release
communicated,
order.
Lordship, down below, Lordship.
Hmm?
Down below, same page, down below on 18th itself. Communicated.
No, Director, how can you utilize his service? And why the order could not be communicated?
It was communicated.
Release order.
The release order.
Release order was not there. At that time, release order was not there.
And also heard Mr. Tobelder, learned at the Standing Council for the Higher Education Department. The debates being sought to be addressed in this petition by the petitioner is that he was serving as lecturer, mechanical auto engineering at the Kamloops Polytechnic, Bayatasarili. The sum for the period 16/10/2024 till 16/1/2025. And initially he was engaged as guest faculty on 28/7/2019, and he continued in the same position and rendered his service in the Kamloops Polytechnic till his verbal release by the respondent number 4 on 15/10/2024. Then thereafter, the petitioner was requested by the college authorities to render his service, notwithstanding the purported release of his service. And finally, the release order was handed over to him on 18/1/2025, with effect from 15/10/2024. In spite of the fact that the petitioner had rendered his service for the aforementioned period. And he has not been paid salary for the aforementioned period by the respondent authorities. Mr. Sharma, learned counsel for the petitioner, taking this court to various annexures from page number 21 to page number 70,
My lord, 27 to 51.
27 to
51.
take the rest of the annexures.
The rest of the annexures, your lordship, the rest of the annexures are some, the attendance sheets, your lordship. The
Okay.
attendance sheets start from
some
page
extent.
37.
Some
And-
extent. The petitioner was handed over the release order by memo number AAM/ES/23/24/20 question bracket capital A dated 18/1/2025 with effect from 15/10/2024 and taking this court to the annexure Z from page number 27 to 51. Mr. Sharma submits that his service was utilized by the respondent authorities till
16
the date of his handing over
Yes.
of the release order dated 18/1/2025. And the petitioner is entitled to receive salary for the aforementioned period for the service rendered by him. Then as such, Mr. Sharma contented to allow this petition by directing the respondent authorities to release the salary for the period covering 16/10/2024 till 6/1/2025. 16/1/2025. Mr. Tobilder, on the other hand, produces written instruction before this court and submits that the petitioner was engaged as a part-time lecturer in Assam Textile Institute, Guwahati, against the sanctioned vacant post of lecturer in textile technology. But he was attached to Kamrup Polytechnic Bhattacharya. And his monthly remuneration was at the rate of rupees 900 per hour class, subject to maximum limit of 72,000 per month. And as per the terms and condition, service of part-time lecturer may be terminated at any time without assigning any reason thereto. And upon recommendation of Assam Engineering Service Recruitment Board, the government of Assam in higher education within the technical department has appointed 2 numbers of regular teachers in textile technology, namely Anuradha Varman and Kandorpa Kumar Nath are some textile institute Guwahati. Then Kandorpa Kumar Nath that joined on 15/10/2024 as lecturer in the textile technology at Kamrup. Now at Assam Textile Institute Guwahati against the vacant post. Then accordingly, the petitioner was released with effect from 15/10/2024. And that the petitioner had not submitted any work diary to the principal Kamrup Polytechnic for the period 16/10/2024 to 16/1/2025. And under such circumstances, Mr. Govilder submits that there is no merit in this petition and therefore it is contented to dismiss the secretary. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record. And from the page number 26.
27, my lord.
From 27 to page number 51.
Yes.
It appears that the petitioner was engaged in various duties by the respondent authorities. And also it appears that though communication was received about joining of new incumbent against the vacant post against which the petitioner was appointed on 15/10/2024, yet the release order was handed over to the petitioner only on 18/1/2025. Thus, the documents so enclosed with the petition from page number 27 to 51. It appears that the service of the petitioner was utilized by the respondent authorities, but he has not been paid the salary for the aforesaid period. Accordingly, this court is inclined to allow this petition by directing the respondent authorities to release the salary to the petitioner with effect from 16/10/2024 till 16/1/2025. In terms of this WBC instance.
The instruction may be kept as a part of the record. If my lord be,
Instruction produced by Mr. Govilder shall be part of the record.
if my lord is kind enough to grant some timeline for them to comply.
Within a period of 2 weeks from the date of receipt of certified copy of the order, the petitioner shall obtain a certified copy of the order of this court and shall place before the respondent authorities within a period of 1 week from today.
I'm grateful, my lord.
Lordship, can it be 4 weeks, Lordship? Financial implications is there, so it may take time, Lordship.
It's a 2,01,000
There
financial
also
implication for
not-
the state coffers. It seems unlikely, but my friends.
Finance department has also to be consulted because for that, at least minimum 4.
4 weeks, 4 weeks. I'm grateful, man.
May I please, Lord? Lordship, I have taken consent at item 30, I have mentioned, Lordship,
Okay.
in 1st of May. Lordship.
Timing item 1.
But in this case, the petitioner for lordship extends the impugn order at page 18, my lord.
The Khatuniya, you have received the inspection.
We have filed our affidavit. We have filed our affidavit.
File.
Yes, my lord.
What is your stand?
But his first contention was that his spouse, wife, and the petitioner, they are in the same department. But our contention is that her spouse working in a university, which is a other autonomous body and under the administrative control of Director of Department of Higher Education. And he is working under the Department of School Education. So it's a two different distinct entity, my lord. And regarding, my lord, one more his contention that they are going through some medical treatment, my lord. So doctor has advised they are to stay together, my lord. In that uh, context, my lord, our contention is that he cannot leave the headquarter, my lord, because he is a district officer. So he cannot leave the headquarter every day. So if he is posted in a same district, my lord,
Why he cannot be accommodated in the nearby district of?
in case of accommodating in a nearby district also, my lord, he cannot leave the headquarter every day, my lord. Being an district officer, he cannot leave, my lord. This is the mandate of the service condition, my lord. So
His wife can
in,
stay
in,
with him.
in any case, my lord, in any case, his contention posting him in a nearby district also doesn't fulfill his requirement, my lord.
Basically,
So that is why, my lord, and he is working in the same district since from the date of his appointment since 2018, my lord. So he cannot dictate, since a transfer is an incident service, my lord, he cannot dictate the authority where he wants his posting, my lord.
No, that's all right. But your office memorandum is there.
Yes. That office manager does not cover his case, my lord, since this is two distinct and different department, my lord. My lord will find ours in paragraph 5 and 6. And there is no denial to the stand taken by the department, my lord.
No, as they are undergoing treatment, whether they can be accommodated for quite some time in nearby district.
That has already been rejected, my lord.
If it rejected, all right, your memorandum does not cover, that is also all right. But this right to marry and to have a family is
That in fact,
universal.
in fact, we cannot deny.
That is a human right. That is there in the
As
Universal
regards-
Declaration of Human Rights.
As regards the his medical condition, that has not been dealt with the impugn order, my lord.
Where is the impugn order? Page
Page
number?
44,
Page
my lord.
44, my lord.
Page number?
44, my lord.
44. Can he be accommodated in nearby district
Sorry, my lord.
for quite some time?
Nearby district.
May not be in Nalbari.
I'm not saying that I should be posted at Nalbari. Any other nearby district, my lord. There is Borpeta, Bongaigaon, Sirang.
Well, as regards steps regarding the doctor advised to stay together, well, that aspect has not been dealt with the impugn order. But in the reply, opposition, my lord, we have stated that paragraph 6, we have stated, my lord.
Yes.
Paragraph 6, my lord. Yeah.
Being
Yeah,
the.
by line structure, my lord,
Mr.
moreover, even if the petitioner is posted in the nearby district, being the head of the office, he shall not be entitled for strictly for every day to stay together with his wife.
Mr. Katonia, that's all right. He cannot
is our
leave the station. But the wife can leave the station.
Yes.
In her case, there may not be any requirement for staying in the headquarters.
Maybe because she's an assistant officer.
Yeah.
Maybe, my lord. So, my lord, this is our stand, my lord. I leave it to lordship, my lord, but this is the stand of the department.
Okay, we will pass the order.
The
We will pass the order.
of office memorandum also, my lord, lordship, if your lordship peruses the last paragraph of the office memorandum, my lord, that is applicable in the case of the petitioner, my lord.
Page number?
Page 25 is the office memorandum, my lord.
Last paragraph.
Yes, my lord. My lord,
Yes.
from page 26, my lord. As will be seen from the illustrations given above, they do not cover all the possible categories of all cases which may arise. In fact, it is not possible to anticipate all the categories of cases. Each case not covered by above illustrations or under the guidelines outlined above will have to be dealt with, keeping in mind the spirit in which these guidelines have been laid down and the larger objective of ensuring that the husband and wife are, as far as possible and within the constraints of administrative convenience, posted at the same station. Even if, my lord, the illustrations does not cover the cases, then also, my lord, this my lord, says they should be posted at the same district headquarters, my lord, or my lord, say, nearby places. That is one aspect, my lord. And the paragraph 7 of the affidavit in opposition.
Yes.
Paragraph 7, my lord. Page 5, if lordship comes to page 5, relevant portion, my lord. As per 6th line, my lord. 5th line. As per the letter number so and so dated 27/12/2023, the election department has directed to follow the instruction received from the Election Commission of India in connection with the transfer and posting of the officers. In compliance of the above mentioned instructions, transfer of the petitioner from Nalbari is inevitable. Only because of the election in 2024, my lord, he was transferred. Now that election is over, perhaps, my lord, this transfer is not required now. That transfer was made because of the election commission guidelines.
No, even then you are not entitled to remain
No,
in the
I am
same
not,
station.
I am not saying that I should be posted in Nalbari forever, my lord. I'm not saying that. My prayer is that, my lord, as my lord, treatment is going on, my lord, we are, my lord, hoping for a baby, my lord, that treatment is going on. We should be posted nearby, my lord.
Okay, we'll pass out.
My lord. Deeply plus, my lord.
Coming item 4.
May I please, lordship. My lord, the allegation is, my lord, fake and fraudulent document created by one allegation brought against the Parthobatim Bordoloi, Salam Ali and Hafizul Islam, my lord. My lord, I am not in the FIR named accused, my lord, but and I have no knowledge, nothing has been done, my lord. And additionally, has been visited to my house, but nothing has been found recovered. But a similar order has been placed before the Lordship court, and that was in the record, my lord.
Case I received.
My lord, CD not received. They give a short date, my lord.
Heard Mr. B. Islam, learned counsel for the applicant, and Mr. Boisio, learned additional PP for the state respondent, and Mr. Boisio submits that he has not received the case diary and tries for listening the matter. After 2 days, on Friday,
My lord.
My lord, interim may be given, my lord, otherwise.
No,
my
no,
lord,
no,
I'm
let the city.
facing some-
Pending item 5.
May I please, Your Lordship?
This
matter-
instruction is received.
On the last of the Lordship, instruction was sought for as to whether any review has been made or not. Because I was placed under suspension, Lordship, the year 2023 on 27, sorry, 25, 2023. As per settled provision of law, Lordship, a review within 90 days, Lordship, is mandatory.
Mm.
In the event the review is not made, Lordship, the suspension order will have no force at all.
Ongoing, yes. Serious allegations.
He was placed under suspension on which day?
And on 25, 2023,
20?
205, 2023,
23.
my lord.
Still you are under suspension.
Yes, still I am suspension. Lordship, I am relying to judgment, Lordship, on division bench judgment of our High Court and the Lordship, another judgment of Honorable Supreme Court.
Which judgment of Supreme Court?
My lord, that is, yes, let me. Should I have given that to judgment, Lordship? Para 21.
Others already.
My lord, as I said, yes. Para 21. They are saying that departmental proceeding is still going on. Let it be continued, no problem. Departmental proceeding, they are taking more than loss.
Mr. Daso, whether his suspension order was reviewed after 90 days.
That particular portion, Your Lordship, it was not given in the instruction, whether it has been.
What instruction you have obtained?
On the last occasion also, Lordship, another instruction was placed.
As you not.
And which instruction is relevant in the facts and circumstances of the case, you must know.
I will obtain instruction pertaining to that, Your Lordship, whether it has been reviewed or not. Kindly.
No, at 2 p.m.
At
You-
2 p.m.,
you
yes, sir.
Inform today itself.
Published.
Item number 9.
May I please, Lordship? My lord, in this case, Lordship, on the last occasion, Lordship, I have submitted one judgment that will cover, squarely cover my present case, Lordship. I have given to them, Lordship, to go through it. Regarding, Lordship, provincialization of Hindi teacher.
Provincialization of?
Hindi teacher in the upper primary school, Lordship. Para 14, 19 to 22, Lordship. The direction was given to submit their individual representation for the authority.
Paragraph number?
Paragraph 14 is the factual aspect of the case, Lordship.
What is the direction issued?
Direction page 22, Lordship.
Yes.
Sorry, para 22.
The only thing is that their name has not been recommended by the DLC. My lord. Here, my lord, kindly see page 40 of the judgment, my lord. Third line, it is contended that some of the case of the petitioner has been forwarded after the scrutiny by and verification by the district scrutiny committee. Here, my lord, name of the no one has been forwarded by the DLC. my lord.
No, some of the cases, in those cases, some of the cases DLC recommended and some of the cases DLC has not recommended. So similar direction is given.
But
Para 12, if your lordship kindly come,
present
that has been reflected. Para 12 in the judgment.
I have no objection, my lord. Only thing is that, my lord, their name has not been recommended by the DLC.
Yes.
No, here also all the petitioners' names were not recommended by the district level scrutiny committee.
My lord,
Yes.
here, my lord, it is found that school of the petitioner prevails service of the petitioner forwarded the kindly see, my lord, next para 8. It is found that the school of the petitioner have been provincial service.
Para 8 of?
Para 8 of the judgment. my lord.
Para 8 is the submission.
This is submission, man. All these are submission.
Yes.
I have no objection, man.
Okay.
Let them file an individual representation, man. Only thing is that this RT Act come into play after amalgamation of the school, man.
Item number 10.
Yeah, please, your lordship. Matters pertains, my lord, to compassionate appointment, my lord. The petitioner's representation is pending before the DLC, my lord. That is not considered. In the meantime, my lord, the notification was,
There is on division bench a decision of this court.
my lord, not division bench, my lord, the single bench, my lord, of this.
No, in a
bench, my lord.
rate appeal. One rate appeal was pending, that was disposed of by the division bench recently.
That was not disposed of, that was pending, my lord. Learned friend earlier submitted.
Pardon?
My lord, that was not disposed of, that was pending. In item number. My lord, may submit, my lord. My lord, in this case, my lord, the notification 18/9/2024 notification has come, my lord, and that was challenged before this honorable court, my lord. In a writ of bunch of writ petition, my lord, that notification was quashed, my lord, by this honorable court, my lord.
Quashed?
Yes, my lord.
Where is
My
that
lord,
order?
we have also challenged this notification in this writ petition, my lord. Yeah. First, my lord, the order passed on 3/4/2024. By quashing the said notification, my lord, 18/9/2024. And directed the authority, my lord, to consider the cases as per merit, my lord. Without considering the, my lord, notification and Devabrati Tewari judgments.
No, not there. This is being challenged before the division bench.
This, I think, my lord, I think, my lord, this order not challenged, my lord. I am unaware, my lord. The order challenged, my lord, with the division bench of.
Lordship, here in this matter, your lordship,
Order to challenge.
going through the facts, your lordship, at first go. It seems that he was rejected in the year 2013.
Yes, ma'am.
2013. And thereafter he applied after 11 years in 2024. He has reflected that same. And that my friend is referring to your lordship, that is one judgment, your lordship, which has been It is 342/2025. Is that your lordship? And yes. So in that judgment, your lordship, in the last para, para number 10. The last three line, it is again made clear that this order cannot be used as a precedent for cases that are filed on 4/4/25 and thereafter. It shall only apply to cases that are pending before this court as on 3/4/25.
Yes, my lord. My case is, my lord, covered, my lord. It was filed on 18/2, my lord. But unfortunately, it was under objection, my lord, and reported in 8/4/2025. And today is listed, my lord. And today is listed, my lord. So within the, my lord, direction, my lord.
Okay, let notice go at this.
Yes, my lord. Notice was maybe issue. জানো তো সেইকাৰণে তো মই কৈছো ন কভাৰ হৈছে মোৰ
Otherwise, your lordship, if it is filed before this, the due date, your lordship, then your lordship can dispose of the matter with that similar direction. Because cases filed before prior to that date has been directed by the honorable court to dispose it at with time limit of 6 months on the merit of the case. And taking into account the Supreme Court orders, honorable Supreme Court orders.
Where is that decision?
Yes, that is what I did. It is case number is 342/2025, your lordship.
Well, that judgment I have given already, my lord.
342/2025.
The direction
And
for
the last part is that para 10.
I have only this one. This one written.
Para 10. It is made clear that in view of the consent of the parties, this court has not gone into the merits of any of the petitioner's cases that are being disposed of by way of this order, and as such, applications for compensation should be disposed by the concerned authorities on merit as they deem it fit and proper. Decisions to be taken by the concerned should be based on reason, and the decision taken should be communicated to the petitioners thereafter. It is also directed that while deciding the applications for compensation appointment, the respondent authorities cannot take recourse to the impugned OM dated 15/9, which is 24, that is set aside, though the judgment provided therein, that is, development can be considered applied by the concerned authorities.
No, where is the order of setting aside this OM dated 18/9/2024?
It has
My
been
lord,
given that.
my lord,
it is
paragraph
that
9.
While deciding the application for the respondent cannot take recourse to the impugned OM 18/9/24.
My lord, paragraph 9, my lord, the Quashman, my lord. There.
Not take recourse.
There are 9.1, my lord.
Okay, then I will dispose of the.
My lord,
Yes.
my lord, so similar covered, my. Obliged, my lord.
None appears for the petitioner on all bases unless the matter after. 11.
Sorry, item 11.
May I please, your lordship? Lordship, in this matter, petitioner has been selected for appointment to a grade 4 post, your lordship, against the quota of person with disabilities by the state level equipment commission, subject to the condition that his disability be tested by a medical board, your lordship, but the same was not done. Accordingly, your lordship, the petitioner had preferred a repetition earlier, your lordship. Annexure 18, page number 53, there was a specific direction taking into account of the medical
Page
report.
number?
Page number 53, annexure 18, your lordship. Annexure 18, page number 53, your lordship. WBC number 454823.
Yes.
Relevant portion is page number 55, your lordship. Paragraph 4 onwards. Page number 55, paragraph 4 onwards. The same has not been done till.
Where is the impugn order?
No, there is no impugn order, your lordship. Only thing is that they have to comply this order, your lordship, making appropriate decision on the appointment of the appointment.
No, whether any decision was taken pursuant to order of this.
No,
court.
lordship, that is my case, no decision. So in terms
No,
of this
then,
order, your lordship, they has to take a decision, your lordship.
Then why this writ petition, why don't you file a?
Because lordship, there was
petition?
no outer limit given, your lordship. There was no within that specified period that has to be taken. This was not there. I have filed representation since this regard, your lordship, that was also not disposed of. And finally, your lordship, I have referred this writ petition. Notice me, your lordship.
Pardon me, sir?
R.H. Chaudhary, your lordship.
Learned counsel for the petition. This petition under Article 226 of the Constitution of India, the petitioner has read for issuing direction to the respondent authorities, particularly the respondent number 6, to make an appropriate decision. To take an appropriate decision on the appointment of the petitioner in terms of the order of this court dated 8/9/2023, passed in WPC number 458 or 4548 of 2023. The learned counsel for the petitioner submits that the petitioner was selected for being appointed as a grade 4 post in a grade 4 post. Wouldn't make it there, wouldn't make it field level against the quota of person with disabilities at a state level recruitment commission for class 3 and class 4 posts. And that the petitioner is suffering from locomotor disability of 45% due to line girdle muscular dystrophy. But his appointment was kept on hold by the respondent number 6 till final outcome and clearance received regarding his credential status of disability. The learned counsel for the petitioner further submits that earlier the petitioner has prepared one writ petition being writ petition number 4548 of 2023, whereby the direction was issued by this court to subject the petitioner to a medical board to assess his disability. And the matter was remanded to the Director of Elementary Education for taking appropriate decision on the appointment of the petitioner. And thereafter, the petitioner has filed one representation dated
Representation dated lordship. One 14/9/13 and another one on 23/9/2024.
page number
Page number 58, annexure 20, your lordship.
on 14/9/2023 and thereafter
On 23/9/2024.
on
9/2024, your lordship.
23/9/2024. But no decision has been taken by the respondent authorities till date. The submission of the learned counsel for the petitioner needs further consideration at this success. Notice be issued to the respondents. Madam, you are appearing
My lord.
for respondent, all respondents?
No, 1 and 6, my lord.
1 and 2,
1, 6,
1 and 6.
6.
And Mrs. Soduri,
Lordship, for respondent number 4, copy has not been served and Lordship, our name may be reflected in the court case also.
respondent number 4,
Yes, state level recruitment commission.
Mr. Upamunya, you are here?
Yes, Lordship, for 2, 5, and 7, Lordship.
2, 5 and 7. And madam, respondent number 3. Solution officer, returnable in 4 weeks. However, so all are represented
Yes.
or 7? Who is for 7?
First time.
7. Since all the respondents are represented by the standing council. No formal notices are required to be issued, however, explanatory set copy of the petition orders to them during the course of the day. Mr. Soduri, learned counsel for the respondent number 4 submits that his name has not been reflected in the cause list. Let's shall do the needful in this regard. Ms. Sutia, learned standing counsel for the respondent number
1 and 6, my lord.
who will obtain the instruction
Well,
in
I-
respect of
I
this,
will- I will-
this
my lord, if-
representation,
My lord.
representation.
My lord, in regard to the representation, my lord, there is no sign in signature of the department, my lord. Whether
Lordship,
he has submitted,
No sign is given, only docket number, your lordship, 570. So far as practice of that department is concerned, they don't give receipt, your lordship, only the docket number,
Well,
file and on the
may
registry.
verify, my lord may give.
Not that they put seal and signature and receipt.
In the meantime, Ms. Sophia, learned standing counsel for the respondent number 1 and 2 shall obtain instruction in respect of the latest status of the representation filed by the petitioner dated 14/9/2023 and 23rd/9/2024. Please the matter after 4 weeks.
Obliged, lordship.
Item 47.
Item 47 and 48 are both similar. In item 47, my lord, the principal prayer in the writ petition is seeking provincialization or getting government concurrence. Since I have been operating as a junior college since 1994. Now, my anxiety is that, my lord, the last year, colleges such as mine or schools, my lord, with HS 11 and 12, the Darpan portal for registering students under class 11 or enrolling students under class 11 was stopped. Now, last year, certain schools approached this honorable court and they were able to get interim orders. Your lordship will find it at page 35, your lordship. Page 35, the order starts, my lord. Page 36, notice was issued. The prayers were similar in those petitions also, my lord. I appear in those matters. And in the interim, my lord, the protection was given that the Darpan portal should be kept open till 25th of September 2024. Because that was the deadline, my lord. Now, I was able to enroll, I didn't approach this school, these two schools for item 47 and 48. I didn't approach because, my lord, there were no students since the Darpan portal was closed. No students approached me. However, these particular institutions, 6 of them, they came before this court and got the interim prayer, my lord. Now, my lord, again, the portal has been made live since the notification is of 12th. My lord will find it at page 38. Very decent copy. Page 38, the notification is of 12. And the portal is left open from 17th to 24th, that is tomorrow. For enrolling students under class 11. And your lordship will see that there's one small note below in the very middle, my lord. The very middle, just below the first table. However, for the students who did not get admission as per above timeline, the portal will be made live again for a period of 5 days before 15. So provided today, if your lordship passes an order for me to enroll students under the Darpan portal, and tomorrow I get the chance, and it's closed again tomorrow, then again before 15th of May, for 5 days, I will again get some chances. Now, the principal prayer that your lordship will observe after issuing notice, my lord, that is my prayer. But for the time being, my lord, let me have some students.
Will be pleases your lordship. Here I would like to give objection, your
No,
lordship. because-
madam, first I'll let him complete.
That is my prayer, my lord, because in the other issues, in those 6 petitions, your lordship has given me permission for listing urgent IAs yesterday. Those particular writ petitions along with the interlocutory applications are listed before Honorable Court number 24 today under the orders column that is yet to be taken up. So there I have sought for an extension of the interim prayer, which I have already shown your lordship. So the interim was only, there was a time specified. So I have sought for a extension till 15th of May. There also I'll make that prayer. Now here there are 2 fresh schools. My lord, kindly grant me the protection, at least till the main issue is observed. And in those matters, after notice was issued, the matters have not yet been listed, nor the department has filed any reply. And I am not seeking, my lord, I understand that under 226, this court cannot direct the authorities to provincialize the schools or the teachers, my lord. The only direction will be the exercise which has been kept pending since such a long time, after submission of so many reports from the authorities, from the inspectors, which I have annexed. That can be brought to a logical conclusion.
We cannot issue directions?
My lord, because the exercise is still pending, my lord.
Still pending.
The inspector have submitted multiple reports after inspections, my lord. That exercise is pending. So my final prayer will not be in the repetition that if the authorities will provincialize my school. I'll seek for a direction to complete the exercise. There might be something here or there also, my lord. But in the meanwhile, at least let me enroll some students.
Yes, madam.
May it be pleases your lordship. Here in this matter, your lordship, SEBA board is a necessary party. Wherein in the cause list also, your lordship, only secondary education has been reflected, name has been reflected. So here, your lordship, SEBA is the necessary party.
They are party.
Your lordship. And in the cause list itself, your lordship, only secondary education has been shown. And pertaining to that, Darpan portrait, your lordship, the area, your lordship, 25 to 26, your lordship, I need to obtain instruction why that college, why that has not been permitted, your lordship. Earlier, Darpan portrait, that is 24 to 25, your lordship, on the ground that the petitioner school falls under the category of non-permitted private institution. So pertaining to this one, your lordship, 25 to 26, HS first year for the session of 25 to 26, we have to take instruction. And Darpan is basically, your lordship, is SEBA board, your lordship. Is the main.
Also, I don't know, 47, 48, my lord. Our name is not shown, even copy has not been sharp to us.
Yesterday I gave copy, my lord.
So far, regarding opening of Dortmund portal, Dortmund, my lord, we will have to answer. So our name is not shown and also copy has not been sharp.
If the courtmaster checks the notice, then perhaps my clerk has served a copy yesterday. Because in those matters before court number 24, my learned friend has been served a copy, his name is also showing and will appear. The 4 and 5.
It's regarding, my lord, extension of the earlier interim order. That session was 24-25. They, as per interim order, earlier, my lord, interim order was session 24-25. According to the, my lord, as per the interim order passed in the earlier, my lord, we have allowed them to take admission provisionally. That interim order was for provisionally. Now they are paying for extension of in this same petition. It is not maintainable. Because session is 25-25, this notification. So I will have to obtain instruction of what is the position. And I have been, my lord, told by the secretary, so person has applied for Dorpon portal for session 25 and 26. Whether they have been allowed or rejected, I will have to obtain instruction. This matter may be taken up in the Friday one.
Friday,
You
tomorrow.
know,
is
I will get it.
Tomorrow is the last. But tomorrow.
Yes, sir, that has been sure, my lord. But they may not mention it. So submission, application was submitted before the council. So that was but rejected by the council because they are not permitted school. Be that as it may, my lord. So better maybe fix it, my lord, Friday, my lord. I will satisfy lordship, my lord, what is happening actually. And another matter is pending in the court number 24, yet to be listed, yet to be my lord, called, my lord.
Oh, let it be on Friday.
But tomorrow, man, because 24th, tomorrow, your lordship has seen
No,
the
no,
notification, man.
Tomorrow is the last day. They are moving today. What is this? There is enough time.
No, lordship, has
There
seen
was
the
enough time.
the notice
No,
was
no,
issued
sir.
on 12th, my lord. The
Well,
court has reopened on Monday.
No,
Today we are sitting on
Only
23rd. What is this submission, my lord?
question of-
Even
question
they will
of
issue the
code.
notification when the court is on holidays.
Why
This is
question
not
of
a submission
code?
to be
You
made.
are
No,
allowed
no,
to,
no.
after 24 appeal, you are allowed to submit application. Why you did not submit application? Why you come to the court? Always court will give an interim order. You will go to the.
That is
It is not a way. Let it be on Friday. I will clear it.
No, the time period
This is
will
not
be
a
over.
banana, my lord. They were, repetition are pending for a session 24-25.
No, Mr. Sotia, tomorrow is the last day.
No, last date maybe. Lordship allow that, then we will allow that in Friday. No problem.
Okay.
Last date for those who have got permission
Yes.
for them.
Okay.
They are not permitted in school. If they are permitted, they will be allowed. Whether they have submitted or not. That is the main question. If they submitted, whether allowed or not. Tomorrow is the last date. Last date doesn't
Let
mean
it
it is
be
not a
on
service.
Friday,
pattern.
the meantime, he will obtain necessary instruction. Will, if necessary, we will issue direction. Heard Mr.
P. Bharadwaj.
P. Bharadwaj, learned for the petitioner, and also heard Mr. Sotia, learned standing counsel for resolution number
4 and 5.
resolution number 4 and 5. Sir Sotia submits that he may be granted some time to obtain necessary instructions. Here is extremely allowed. Recital is the matter on Friday.
My lord, I am for the 4 and 5. Our name may be soon, my lord. SC,
Recital is the name of
SSEB.
S.
ASSEB. SC.
ASSEB.
Assam edition new nomenclature of Assam State School Education Board. There is no SEBA, no council.
Okay.
Obliged.
And 1, 2, and 3.
Okay.
That is for admission, item 12. 100 meter.
Sorry, lordship. Time being on leg, foot number.
Item 13, 500 meter.
Okay. 14.
Item 13.
He was there, my lord. He actually, he wanted to seek time for filing reply.
Okay, after some time, let him come.
Yes.
Item 14. 500 meter.
May I please as your lordship? My lord, may be pleased to take up the order dated 2/4, my lord, passed in this petition, my lord.
Yes, Mr. Fukan.
You will kindly check the last order, my lord.
Regarding the status of file number 228806.
My lord, as far as the elementary is concerned, we are still awaiting the current status. But regarding the finance, my lord, I don't know, my lord, whether they have got the status or not. We'll have to get the information from the government man. Because from the directorate it was sent, it is, I think, lying in the secretariat, the government side. So, my lord, we'll give some time, my lord. Otherwise, the finance, I don't know what their stand is. That's what.
My lord, may I pray, my lord, it will resolve the entire issue in just a, my lord, if my lordship directs the contemner to appear personally, my lord, it will resolve the entire issue, my lord. What they are doing, my lord, the elementary education department is pushing to the finance, and finance is again sending back to the file to the, my lord, my lord, elementary education department. They are not at all willing to comply with the, my lord, several directions passed by this honorable court. my lord.
Lordship will not give issue any this thing, my lord. I will get instructions regarding the, my lord, as far as the department, elementary education is concerned.
Lordship, if I may, Lordship, I will just receive my instruction. Lordship, the proposal has been sent by the education department clarifying all the queries that has been raised by the finance department. And it has been sent to it's pending in the finance department. They're seeking 2 weeks time, Lordship. In none of the proceedings, earlier proceedings also, finance was never consulted. We were not aware, Lordship. So, we were not a party. And in this writ petition also, we are not a party. Now, the finance department is asking for 2 weeks time to process the claim of the petitioner. And here, Lordship, if the speaking in all the directions, there was a direction to consider the case of the petitioner, pass a speaking order by the Commissioner and Secretary of the Education Department. For that, Lordship, some verification and some queries were raised, because of which some time is being taken. So, Lordship may grant me to the finance department 2 weeks time. We are not even a party, Lordship, but we will take a decision, and from there, education department may proceed, Lordship. Lordship,
My lord. My lord.
Lordship, here the question regarding provincialization, because there are other parties, there were two appointment letters also. Similar, there were other people making the same prayer for being provincialized as science teacher, like the petitioner, Lordship. So those counterclaims and all have to be examined. And in all the court's orders, same thing has been reiterated, that proper verification has to be done, and upon verification, a nice proper reasoned order has to be passed. And where there are two other petitioners also, Lordship. So the rights of those petitioners are also included.
My lord, with all respect to my respected friend, my lord, what he has submitted, the entire issue, my lord, culminated and summarized in the speaking order at page 102 of my writ petition, my lord. That speaking order is under challenge before my lordships, my lord. And my lordships, going through the entire order as well as the speaking order, my lord, passed an order to pay the salary from the month of January of 2024, my lord. But it is almost 1 year has lapsed. Now they are saying that we have to sit over again and examine the issue. My lord, with all my limited knowledge, what I respectfully beg to submit, my lord, they are now wanted to treat them as an appellate authority. When the matter is in lease, my lord, before my lordships, my lord, they cannot reopen the issue. They have to file till date, my lord, in my writ petition. Neither the, my lord, elementary education or nor any other authority has filed the affidavit, my lord. They are sitting silent. And on the other hand, my lord, they are not also complying with the order of this honorable court, my lord. Very unfortunate.
No, Lordship, Lordship, here in the reason order also, Lordship, Lordship, in page number 103, Lordship, the decision which the authority has taken, Lordship. If I may take my Lordship to page number 103, Lordship, the decision. In view of point 1 to 6 and point 7 and 8 of the above, the Director of Elementary Education, Assam, will process the matter of provincialization of services in respect of the petitioners, Shri Korman Ali Sheikh and Shri Moinul Haq, as well as respondent number 7, Shri Soriful Islam, as per the provisions laid down in Provincialization of Services Act 2017. With due recommendation from the concerned district scrutiny committee, and by placing their proposals before the state level scrutiny committee for further verification as per Act as well as the decision of the joint committee in minutes dated so and so under clause 24 of the Provincialization of Service Act 2017, Lordship. Claim of the petitioner has not been rejected, Lordship. Lordship, in the previous orders also, the Honorable Court has directed the Commissioner and Secretary in the Education Department to give a reasoned order because there is some contradiction regarding the appointment of the petitioners. They have filed writ petitions before also. So now, Lordship, I am appearing for the Finance Department and I'm just seeking 2 weeks time because we have to verify all the appointment orders because there are certain there are allegations from the private respondents also that they are entitled for it. And they have also produced appointment orders. My learned friend wants to be provincialized as a science teacher. Common Ali Sheikh, Lordship, who was also, his services has been provincialized as an assistant teacher, but he has also produced an appointment letter where he was appointed as a science teacher initially. Now, these the only reason we are taking some time is to verify, and that is why we are raising these queries with the Education Department, Lordship. In the earlier round of litigation also, they have, the other side, they have also been able to produce appointment letters, and that has been observed in the previous orders also that there is some anomalies because of which sometimes I am appearing only for the finance. We have not been made a party also in this matter.
My lord, what my learned friend is praying for a time, we do not have any objection regarding that. But my lord, the manner which my learned friend is submitting and projecting that they want to verify, then my lord, a mandamus which has been issued by this honorable court, can that mandamus be, my lord, diluted in this manner, my lord? It cannot be, my lord. Now the attempt which they are trying to, my lord, project before my lordship is that the mandamus is not, they cannot comply with the direction. If it is not a compliable order, my lord, there are other remedies are available. Review petition has also been filed against the order, my lord. That review has also been rejected. Against the order which, my lord, a contempt petition has also been, my lord, pending before this honorable court, my lord. This is totally, my lord, unacceptable
We have not
position. my lord.
rejected the claim of the petitioner, Lordship.
No,
We
no,
are-
my learned friend is saying that they wanted to further verify that who is entitled to the salary.
No, Lordship. Here,
That is his submission,
no,
my lord.
my submission is that report has been submitted by the authorities in the Education Department to the Finance Department, Lordship. So, Lordship, we as a Finance Department, we also have a responsibility to make sure that everything is done as per the law laid down and due procedure is followed. So, Lordship, some verification time is required from our end. I'm only representing for the Finance Department, Lordship. And we were not even made a party here, Lordship.
Mr. Bhuya,
My lord.
oh, let us wait for 2 weeks. Let us see.
Lord, we are waiting, my lord. We are waiting. There is no problem, my lord. But the only issue, my lord, is that, my lord, the direction passed by this honorable court has not
No,
been.
they cannot
My
examine.
lord.
They cannot
examine, my lord. Now that is the issue, my
No,
lord.
we are only processing, Lordship. I'm seeking time to process the claim.
My learned friend's submission, with all respect, what my learned friend is submitting, one hand is saying I am processing, and on the other hand, my learned friend is saying that they are examining. Not personally, the officers, my lord, which the officers are doing, my lord. That's the problem, my lord. That's why my salary, in spite of 2 directions, my lord, has not been paid till date, my lord.
Okay,
I can wait, my lord. I will always oblige to follow my lordship's observation, my lord.
Third, Mr. Bhuya, learned counsel for the petitioner, and Mr. Pukon, learned standing counsel for the respondent numbers 1, 2, 4, 5, and 6. And Mr. Bora for respondent number 3. And Mr. Solia for
We are not a part for the Finance Department.
Finance Department. Person to order of this court dated 2/4/2025. Mr. Pukon and Mr. Solia apprise this court that the file number 228806 is now pending in the Finance Department. And the Finance Department is verifying the matter and will complete the entire process within 2 weeks. Within 2 weeks, and Mr. Solia price for granting in 2 weeks time. There is accordingly allowed. Recessal list the matter on COVID exactly after 2 weeks.
On 15th May.
15th May.
My lord.
15th.
My lord, there is an interim.
Interim order was earlier seconded.
Oblige, highly oblige.
Number 2.
Wait, please, your lordship. It's a compensation appointment, lordship.
Yes.
The connected retables are pending, lordship, as per my instruction, lordship.
Pending.
Pending, lordship, and the matter has been fixed on in the first week of June, lordship. Before the honorable division bench.
So here also you have challenged the same office memorandum
Redating is pending, lordship.
pending. Okay, let notice go ahead, this is this.
Yes, lordship.
Heard Mr. Bora, learned counsel for the petitioner, and Madam Borman for the for this. Any other, Madam, you were representing all the respondents?
No, actually, education department, lordship. And actually, this is MCV and lordship, autonomous council, lordship. One for one only I will give.
You were appealing for one. Okay. So, no, sir, this commissioner and secretary to the October some secondary education department.
Second. Second two.
Mr. Yu Sharma for respondent number 3. 3 and 5. 3 and 5. This petition under Article 226 of the Constitution of India, the petitioner has challenged the office memorandum.
Office memorandum dated, lordship, 1st of June 2015, Annexure 13, lordship.
Setting aside the impugn office memorandum dated 1/6/2015. And also the letter dated 6/8/2021.
Yes, lordship.
Issued under memo number COFT stroke APPT stroke part 2 stroke 2021. Issued by the respondent number 7. Whereby the appointment of the petitioner under compassionate ground was not considered. On the ground that the compliance of the requirement of clause 1 of the office memorandum under number ABP stroke 50 stroke 2006 stroke part PT stroke 182 dated 1/6/2015 not fulfilled. Let notice be issued to the respondents, returnable in 4 weeks. Submit taken by registered post with ADN also by visual process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 3, and 3 and Mr. Sharma, you are for 3 and
5.
3 and 5. 3 and 5. Yes. They are represented by their standing counsel. However, extra requisite copy of the petition be furnished to them during the course of the day. Tip upon rest of the respondent be taken within a week from today. list the matter after for it.
Coming item 13.
Publish.
Partner matter.
Please, your lordship. Lordship, in this case, we need to file and reply, lordship. File affidavit in opposition filed by respondent number 2, lordship.
When
Within 5 days, my lord.
it is not on record,
It must be there, my lord. It must be there, my lord. We have received, lordship, their copy.
you have received.
Lordship. On 10th of April, we have filed. my lord.
Oh, you have filed,
This one.
you have filed a reply.
No, we'll file the reply, lordship.
You will file a reply.
Okay.
Or Mr. R. Popam, learned counsel for the petitioner, and Mr. S. Das, learned counsel for the respondent number 1 and 2.
This one. Only 2.
Then Mr.
I got 3 and 4 in the company.
Mr. Kakoti,
Yes, sir.
respondent number 3 and 4. Mr. Popam, learned counsel for the petitioner, submits that he has received a copy of affidavit in opposition filed by the respondent number 2, and he will file reply to the aforementioned affidavit and press for granting in some time. There is allowed recess is the matter. After 1 week,
Lordship. So the date may be fixed, lordship.
okay.
14th May.
Lordship. Obliged, lordship.
Item 15.
Lordship, hearing this matter, they have filed a affidavit in reply, Lordship. I have received it, Lordship. I need some time to go
Whether
through.
you have deposited the final amount.
Yes,
Lost
Lordship.
amount.
Yes, Lordship. That
When?
Lordship, that has already been deposited, Lordship.
Where is the receipt? Okay.
Last ever came, isn't it? Cost was deposited, my lord. I have been informed, my lord.
You have been informed?
Yes, I have been informed, but online it is showing that deposited.
Okay.
So, my lord, my prayer is, my lord, one thing, my lord. If it is cost is imposed, my lord, that should be, my lord, in the welfare of the advocate rather than the employer, the High Court, my lord. Because they are getting all the things, my lord. The advocates are not getting anything. So, why where will be there, my lord?
Okay, next time we will.
At least, my lord.
So you have filed your affidavit.
Yes, Lordship, they filed a reply, Lordship. I need some time to go through and file a counter if necessary, Lordship. So after a week, Lordship.
After a week.
My lord, that may be fixed on 8th, my lord.
May.
Some difficulty on 8 May, if it could be on 13th of May.
13 better. The 13, another my hearing matter is there. my lord. That's it. Then on 15, my lord.
15.
15 is Tuesday.
Thursday.
Okay.
Heard Mr. P. Monto, learned counsel for the petitioner, and Mr. P. Fomento, learned counsel for the higher education department. Then Madam Agarwala for
Dr. P. Respondent number 3.
respondent
UGC,
number 3. Respondent number 3. Mr. Upamunya, learned counsel for the respondent number. State respondent submits that he has received a reply filed by the petitioner, and he needs some time to go through the same, and if necessary, he will file a reply to the counter to the aforementioned reply. There is accordingly allowed recess and later matter on 15th of May.
Mass supply.
Thank you.
Item 16.
Right, with your Lordship. Also, this is a part matter Lordship was hearing regarding payment of interest part and the earned leave, commuted leave that was wrongly calculated. Last occasion, instruction was sought by from a.
I have received the instruction, my lord. So I have a copy to my learned friend also.
So what is your instruction?
If he is not entitled for 15 days earned leave, my lord. Third paragraph of the instruction.
Just now I received it, Lordship. I have to go through. I'm just going
Yes,
through.
my lord, I will, it's better to file an affidavit to this effect, my lord. On the
You
basis of
want to file affidavit?
short affidavit covering this point only, my lord, because the remaining part regarding the area salary that has already been paid to him, my lord. Covering this, only the issue of earned leave, my lord, 15 days of earned leave, that I will place it on by way of an affidavit. Then he can, if he wants to reply to it, my lord, he can give a chance to reply, my lord.
Okay.
Oh.
Ordinance Monto, learned counsel for the petitioner, and Mr. Attorney for standing counsel for the respondent authorities in secondary education department. Secondary or elementary?
Secondary, in this case, secondary.
Secondary. Mr. Katonier submits that he has received inspection, and he may be granted some time to place the same by way of an affidavit. Where is accordingly allowed, recess unless the matter on
After 10 days, my lord.
after 10 days.
Matter to be shown as parted only. Even is parted.
Okay, recess unless the matter is parted.
Item 17.
Obliged.
Lordship, as per the last,
Only peruse the last order.
Lordship, I have received the instruction. As per the Lordship, I would like to bring it on a affidavit, additional affidavit. Lordship.
This case relates to non-payment of salaries, my lord, and they have been terminated as a teacher, my lord. But we are working as a gate 4, my lord. And several order has been passed by this honorable court that pendency of this rule, there is no bar to pay the salaries to the petitioners, my lord. They did not pay any heed to it, my lord. Several times they have filed affidavit. And recently they brought instruction, my lord. Last occasion, they brought instruction and filed affidavit and did not mention anything about one letter, which I have been filed along with this letter, my lord. Now he stated that he has bring another.
Lordship, that letter was not known to me and I have subsequently got the clarification. And secondly, Lordship, with regard to the issue that they were terminated and again reinstated, Lordship, about lots of cases are pending and that is heard before court number 17. And that is
That's
scheduled to
but
be listed tomorrow, Lordship. Even then, Lordship, whatever
that case
instruction
is,
that.
my lord, that case is regarding the teachers. We are gate
Lordship,
4, my lord.
many
Why
issues
you
are
not
there.
admitted that?
Lordship, with regard to the clarification that I have received, Lordship, I will bring it on record. Only, Lordship, 10 days time, Lordship. I'll bring
Lordship,
it.
kindly peruse the order dated 16/6/2023. There are several orders, of course, but 16/6/2023 also, this honorable court passed an order regarding the payment of the salaries, madam. The instead of this repetition will not be bar for releasing the current salaries and also area salaries to the petitioners. But in spite of that, they did not say anything about that. And recently he bought one letter, my lord, and bought a filed affidavit, my lord. And now he would like to file another affidavit. But we have not been terminated till now because they have terminated as teacher. We are still working, continuously working, my lord. But I am working as a gate 4, my lord. That is the point, my lord.
Okay.
To admit, sir.
Let it be after 10.
Yes, my lord, yes.
Third is a table learned counsel for the petitioner and Sodri for respondent number. All the respondents.
For BTC, Lordship.
Uh, 1, 2, 3. We're taking in.
Lordship, 1, 2, 3, 4,
4,
5.
5, 6. That's come. WT.
Who is for finance department?
WT.
Lordship, C is every.
7.
C7.
Good name, please.
6 is finance.
Art?
Finance group. That's it. Good. Thanks.
Respondent number 7 and Madam Borough for respondent number 6. Respondent number 6, Mr. Sodri submits that he has received some additional instruction and he will place the same on record by filing an affidavit by way of an additional affidavit and price for granting him 10 days time. There is accordingly allowed. This is the method after 10 days.
It may be fixed, my lord.
Okay.
On 20, 20.
20.
I do black.
Matter number 18.
18, my lord, we have filed one.
Also,
I
here also,
Similar, my lord. Okay, lordship, can we take this matter along with this?
Okay. Both the matter.
Hope that appear to be said.
19.
Like it.
Lordship, here also the issue is the same. They were terminated and reinstated in 2015. Lordship, that issue is pending before part matter in court number 70. There are several other matters and those are listed fixed for tomorrow, Lordship.
Hearing?
Yes, a hearing is going.
Lordship, that matter was, those matters are filed on 17 and 18 in the year of 17-18, and these two matter was filed on 2023. And petitioner was reinstated on 16 October 2015, page number 36, annexure 12. And they were regularized and they are working from reinstate. And they are asking for area money 16/10/2015 to 14/7/2022. From 2022, they are getting their regular salary. So those, in those cases, some of the petitioner did not get their regular salary and some of them get. So matter is little bit different, my lord. So these two petitioner, they are reinstated in the year of 2015 and they are still continuing. And from 2022, they get the monthly regular salary. So that period, the area salary may be released, my lord. Simple player, Maya. They are working, that is established, my lord. They are reinstated and regular.
You have filed your affidavit.
Yes, Lordship, here we have filed our affidavit. But Lordship, the issue in some of the cases, Lordship, some are claiming from 2015 to 2022. Some are stating that their appointment in the substantive post in 2022 is bad. So they are claiming for salary with effect from 2015. Lordship, ultimately the issue remains the same. From 2015, everyone is claiming for area salary. Lordship. And some of them are receiving the regular salary from 2022 and some are not, Lordship. But the starting point starts from 2015, Lordship.
Lordship, kindly.
That's
see
what,
the-
Lordship, because the issue is
Lordship,
being heard and part heard before court number 17. That's why Lordship may take it up after 2 weeks. In the meantime, or Lordship may tag along with the series, Lordship.
Yes.
It is
earlier that these two
602017.
matter was with tag with that matter. I have segregated this matter because their issue is a big issue. Some of them getting and some of them did not get. And
So this
their-
petition was segregated from other petitions.
Yes, yes. And my lord, dear, kindly see the page 36 where it is clearly written, the regulation order shall come into force with prospective effect, my lord. So if prospective effects and they were continuing after reinstate till 2022 and after 2022, they have getting their monthly salary. So if they are reinstated and regularized and they are, why their salary will not be payment and for that period? There is any amount.
Oh, let it be on the next Tuesday.
Yes.
Hearing day,
Next Tuesday, no, my lord, Thursday, my lord, Tuesday I
Thursday.
have some.
Thursday. Yes, I did by learned advocates of both the parties. Yes, it's always the matter on Thursday. Thursday.
Lordship, Lordship may take, I've got some problem, personal problem on first, any other date thereafter, Lordship.
5th of month, May.
Yes.
5th of May.
5th of May.
Monday, that will be.
Item 20.
Lordship, it's same, it's the same matter.
If the matter is perfect.
20.
Similar. Similar.
21.
26.
Hi, please.
Yes.
In this case, my lord, the petitioner was left out from the purview of my lord provincialization. of his service, my lord. He has submitted one representation, my lord. And my lord, I'll take your lordship to page number 67.
There is a direction to produce page number 54.
Earlier, my lord.
Yes.
Earlier in wait a minute. It was earlier a round of litigations, my lord. Thereafter, my lord, I take your lordship to page number 67. This is the proposal forwarded by the my lord district elementary education officer to the director, my lord.
Page number
67.
Yes.
Whereby the proposal was application of the petition was forwarded by the district elementary education officer to the director, my lord, elementary education. Actually, it was supposed to be placed before the my lord district scrutiny committee. Instead of placing the matter before the district scrutiny committee, it was placed before the director elementary education officer, the director elementary education Assam. So, my lord, that's why the claim of the petitioner could not be considered properly. As per law, my lord, it is the district level scrutiny committee has to consider first. Thereafter, if they recommend, my lord, then the matter will go to the state level scrutiny committee. That my humble submission, my lord, the petitioner has submitted one representation also at page number 71, my lord. That has not been acted upon. That has not been decided, my lord, yet. And he was left from the purview of the provincialization. The school was the page number 69. Your lordship will find a list of candidates teachers has been published. Serial number 567. Three teachers of the said school, but all of them petitioner was the Arabic teacher, and Arabic teacher was serial number 5, my lord. He has retired before the provincialization. Only the grade 4 of the school at page 70, his service was provincialized. No teacher was provincialized. And it is attached to the base school. And petitioner service could not be provincialized. That's why, my lord, as already the proposals have been submitted by the district elementary education officer to the director, and through the DLC, the case of the petitioner could not be placed, and therefore directly sent to the, my lord, district director office, page 67, that letter. Which and as a result, my lord, the case of the petitioner has not been taken into consideration. My humble submission before your lordship is that just this case may be disposed of with a direction to the district elementary education officer or the director, my lord, as the matter has been placed before the director, forwarded before the director, to place the case of the petitioner for consideration before the district level scrutiny committee. Because they have to consider first, then only whether he is recommended or cancelled, then only this next course of action will come. Otherwise, nobody will can entertain his claim, my lord. Neither the director nor the district officer in its independent capacity nor the government can take the decision. It has to go to the district level scrutiny committee first. Then only the matter will be decided on the basis of their recommendation, subject to their consideration.
Yes, so who is appearing for respondent authorities?
I'm appearing on behalf of the elementary department, madam. Here, my lord, representation is pending before the director, my lord. Page 71.
Page
71. Annex 9. This is pending, my lord, before the director. So the action may be given to the director to dispose of this representation.
With regard to my placing of his case before the district level scrutiny committee.
Your name was not there in the you guys data.
Yes,
For the year 2009 and 2010.
yes, Lordship. Even if the UDA's data is not there, that cannot be the matter of rejection, my lord. It has to be disabled. I have annexed the judgment, my lord, page 77, the order of listing. It can be physically verified whether an employee was there or not in the existing, even if the name is not there in the dashboard, that will not. my
Page
lord.
number?
Page number 75, I have given the final judgment is not, the interim order was there. The final judgment, let me take just a minute. I have page 88, my lord, annex 11 in my reply. I have given the annex the judgment, my lord. Even if
Paragraph number?
paragraph page 93, last paragraph, in that in the terms of such and such, the state level scrutiny committee is to carry out a physical verification of the institution and also cause an inspection of all relevant documents and records as may be required for the purpose of arriving at its decision with regard to the case of a serving teacher of a venture education institution being considered for this provincialization of his or her services. Such exercise would also bring with its fold a verification to ascertain as to whether such employee was in continuous service of the said venture education institution with effect from date of his or her appointment therein. The said procedure as contemplated under section such and such of the act has admittedly not been followed by the case of the petitioner, in the case of the petitioner, and his claim for provincialization of service came to be rejected solely on the ground that his name did not figure in the data till the year such and such. In the procedure as mandated under the provision of the act and such having not been followed in the matter, the court is of the view that the conclusion has reached in the such and such order stands recited and the same is required to be interpreted with. So even if, my lord, the name is not in the dashboard, my lord, it can be physically, alternatively, my lord, it has to be.
Sparta Act is mandatory, no?
Yes. Even if the name is not there, physical verification has to be done.
What is that order?
Page 94, my lord. I've just read, my lord. Page 93 of the order dated of the affidavit in reply filed by the petitioner.
Where is that order of this court?
This code will start, it starts from, my lord, page 88. And you also will come to page number 93 of the affidavit in reply.
No, you have submitted that there is a one order of this court.
Yes.
That without that I asked for the.
Yes,
it
Lordship,
can be
page,
verified.
it's annexed with the affidavit in reply. Affidavit in reply.
Page number.
Page number in that affidavit in reply, page number 94, 93.
93 is the affidavit in reply.
Yes.
The order of this court.
Yes, my lord. WPC number 2426 2023.
Is it part of the record?
Yes, yes.
Page number.
Annexure 11A, page it starts from page 88. Is the reply to the affidavit of respondent number 7.
No, order of the court.
This is the order of the court, my lord. I think this.
Actually, আমি যেটা reply দিচ্ছি তার হয়তো।
Your my lord, SSA also filed an affidavit, my lord.
That reply-
Confirmed counsel is on late, so matter may be taken any other than.
That is the reply affidavit to A. That page number 93, my lord, you will find the last paragraph.
SSA has filed a.
Affidavit, yes, sir.
Yes, my lord. What is your stand? Well, we have filed our affidavit in opposition, my lord. And it appears that the petitioner's name is reflected in the dice data, my lord.
Page 86.
Page 86, my lord. Page number?
86.
my lord. For the year 2019 to 2021.
This is the notification, my lord, whereby a committee has been constituted by the government recently
Hmm.
for examining the left out cases.
In the dias code, since when your name appears?
Name, my lord, my name 86, page number 86, my lord. It from the bottom, my lord, you also will find Fazlur Rahman Barbia.
It's the year 2020 and 21.
Yes, yes. Because the earlier Arabic teacher was in the, I was the additional teacher of the school, my lord, and the earlier regular Arabic teacher, he retired. After his retirement, my name has been entered in the for the year 1920.
Yes, Mr. Gogoi, what is your stand?
My lord, we have filed a affidavit. In fact, my lord, dice data is there.
No, his name appears in the year 2020-21.
My
not
lord.
prior to that.
It appears otherwise, my lord. It's in serial number 2.
Page number 84.
Page 86. Running page 86.
And that is for the year 2020 and 21.
2021, my lord.
What is the requirement?
Requirement, my lord, as per Act, my lord, it has to be there for 2009.
2009, my lord.
9, 10 onwards has to be there.
You'll have to-
But my lord, if the name is not entered in the DICE data by it is because this is entered by the school management committee through online process. If that is not entered, my lord, that will not take away someone's claim. And this honorable court has settled this position, my lord, that for that purpose, while they will consider the case of the petitioner or any employee, my lord, for provincialization, the district scrutiny committee will make physical verification of the records, and thereafter only they will arrive at a conclusion whether the name of the concerned incumbent has to be recommended or not. My humble submission before this honorable court today is to my lord to give a direction to place the matter before the district level scrutiny
No,
committee.
Before that, let the school managing committee, whoever is there, this must speak before the honorable court whether actually he is working or not. He was working in 2009 or 9 and 10 or not. But they are not a party hearing, manner. They are the one who will testify this part, manner, whether he was there or not at that point of time. Then the question of non-inserting the name will come in.
That physical
This
part has to
petition,
be
my
done
lord-
by the my lord, this process, the petitioner is not supposed, and this honorable court is not supposed to examine this aspect, my lord. This will be examined by the authority, my lord. Yes, because they have not taken into consideration, we are approaching this honorable court. And that rest of the administrative duties will be done by the concerned authority, not by any other, my lord.
Apparently, my lord, I have placed the, my lord, is that
Yes.
before his honorable court. His name is not there from 2009 onwards. Only in 2021 it has been inserted.
Inserted.
So, my lord, probably there may be some reason, my lord. He was not there in the school, maybe.
That will be examined by the district level scrutiny
Why
committee.
is harping on that point, my lord? Let the concerned authority, my lord, may file an affidavit stating, my lord, whether he was there or not, my lord. Education department can place the affidavit, my lord. On that point.
Education department has filed their affidavit, we have filed the reply, my lord.
This affidavit.
They have stated clearly, my lord, in the affidavit that the earlier teacher retired. Thereafter, I was been upgraded. They have filed their affidavit. Master photographer retire করেছে।
School provincial
Master retirement, business provincial by list of already retired. ওকে কথা। লিস্ট তো আসলে গ্রেড 4 তো খালি চাকরি হয়েছে। খালি গ্রেড 4 তো চাকরি হয়েছে।
And one more, my lord, one more point I'd like to point out, my lord. Once the school is provincialized, if after the provincialization, say even very next day also, my lord, if some vacancy arises, that will have to be filled up by advertisement. It cannot be that, my lord, someone will be now added again. Moment it is provincialized, the vacancies whatever occurs subsequent to the provincialization will have to be filled up by advertisement, my lord. Cannot be, my lord, that person below in position will now automatically, his name will be inserted and he will be provincialized.
Not like that, my lord.
It cannot be, my lord.
Before the date of provincialization, my lord, the person concerned has retired. Retired on 31/12/2018, Yasin Ali. He retired on 31/12/2018. The school was provincialized in the year 2021. The question of taking away, grabbing the post prior, that doesn't arise. That issue was asked earlier also. That doesn't arise. Once the person is in service and the post is provincialized and he retires, then in that post, a second person cannot be provincialized. That's correct.
Yes.
But the person retires before provincialization, and after that the post is provincialized. That is that cannot be done also, my lord, because the next person will be in queue. So my humble submission before this honorable court, my representation has not been acted upon as on date, my lord. That may be
Mr. Gogoi, have you got
disposed
for
of.
the representation filed by him?
Lordship.
Of course, it is pending before the Director of Elementary Education.
71.
Mr. Professor, whether your purpose will be served if we direct the
That is, my
director
lord,
to dispose of this
if
representation.
director dispose of with the direction to the district elementary officer, my lord, to place it before the DLC, then DLC will take into consideration whether his service can be recommended or not recommended. It's a purpose will take long time, my lord, but say one step only. That is why my case is before the lordship, my lord.
We are disposing of this rate petition by directing the director to dispose of this no, sorry, representation at page number 70.
Lordship, yeah, that can be done.
71. So, director has to take a decision within 2 weeks from the date of receipt of certificate.
Let it be 3 weeks from at least.
No, 2 weeks, the matter is pending since law. Okay, we'll pass the order.
Well, for SSI, very well.
Twenty-two.
May I please, lordship.
Yes.
This matter is non-payment of family pension, lordship.
Yes.
Kindly use the last order, lordship, 21/3/25, lordship.
Yes.
The Honorable Court directed to place instructions, lordship. Finance Department, lordship. I am not received pension from since 2011, lordship. Family pension.
You have retired in the year 2011.
No, my husband retired. I have received a family pension, lordship. My husband expired, lordship, on 11/7/2011.
So whether you have filed any application or
I approached for a bank authorities, lordship. as well as head of the treasury also, but they had not paying payment lordship, making payment. After that, I expired my husband lordship. My husband received at that time pension lordship. After I expired my husband, I applied for my family pension.
So whether you have filed any application,
I
is it part of the record?
yes, lordship. Only
Exemplary.
page 14 lordship. The next side, lordship. A legal notice has been given to them.
No, before issuing legal notice, whether the petitioner has filed any application to grant pension in her name.
Lordship, that I made a statement, lordship. Kindly page 5 lordship, para 7 lordship. Page 5, para 7 lordship. Thereafter, their death of her husband, the petitioner being the legally married wife, widow of late Siveshwar Deka, retired government employee, and a pension entitled for family pension, and accordingly, petitioner approached the bank authority and treasury officer Morigao, paying for payment of her family pension, and submitted all the requisite particulars, lordship.
Where is that application? Is it part of the record?
No, that I have not annexed, lordship.
Annexed?
That I have not annexed, lordship. But I have also submitted the legal notice on 9/8/23 lordship. There also they have no communication from the bank authorities, lordship, regarding payment or.
So, madam, you furnish a copy of this instruction to him. Let him go through it. We'll take it out in the second half.
Second half.
After 2 PM.
Any other day, lordship, next week, lordship. Also, ma'am, I also can take instruction from my client also regarding that, lordship.
If I may, Lordship,
Yes.
here, it is the bank authority that has to verify and make the payment, Lordship. And from the State Bank has been made a party, but nobody is representing them, Lordship.
Is there any standing counsel for State Bank of India?
Lordship,
As per, they have no standing counsel, but we have, there's a Lozima order, lordship. We have Dusty also given lordship to the bank. There's a Lozima order, lordship. Already
the State Bank can come with a clarification because they are the ones because the nominee, if the petitioner has already been named as a nominee, subject to certain documents verification that the bank has to carry out, they can make the payment, Lordship. That is, no other interference is required from any of the authorities. So if the bank can clarify why they're not paying, and if there is some shortfall of the document, and if my learned friend has already paid a visit to the bank authorities, maybe they can clarify, Lordship. So that is one issue, Lordship. So if State Bank has been made a party, but
they had made a party already, services completed, lordship, as per Lozima order, lordship. And but they also not.
branch to be State Bank.
Ramayang was Raja Mayang. Jogi Bhapat Gao. और ये तो मेन पेंशन पार्टी बनवा है सेटू पेंशन also
My lord,
celebrate-
I am standing counsel.
Impaneled my lord of SBI,
Acha.
State Bank. Yes, my lord.
Can you obtain instruction then?
My lord, I can take instruction, my lord.
Okay.
As to why the thing has been pending.
Okay, you furnish a copy to him
Lordship.
of this writ petition.
Lordship.
Heard, sir, your good name, please.
KD Sharma, lordship.
Learned counsel for the petitioner and Mr. Sobiha for
the Treasury.
Finance Department.
Respondent number 3, Lordship.
Respondent number 3. Then Mr.
I'm for the respondent number 4.
Mr. Yusoma for respondent number 4.
Yes.
Directorate of Pension. Ms. S4 for respondent number 5. Respondent number 5 and Mr. Sen, BK Sen, learned. Standing counsel or panel lawyer? Panel lawyer. Learned panel lawyer for the respondent number 2.
1 and 2 Lordship.
Respondent number 1 and 2. This person to order of this court dated 21/3/2025, Mr. Solia has produced the inspection he has received from the finance department. And submits that it is the bank authority who has to clarify the matter as to why the pension of the petitioner has not been released. Mr. Bikis and learned panel lawyer for the respondent number 1 and 2 submits that he will obtain necessary instruction. And press for granting him some time, here is allowed. It is provided that learned counsel for the petitioner shall furnish a copy of the writ petition along with the instruction received by Mr. Solia and placed before the court today to Mr. Sen during the course of the day. List the matter on. We'll fix it at 16.
My lord, saying the cause list, it is not reflected that SBI.
Cause list.
Yes.
Rest shall reflect the name of the respondent number 1 and 2 in the cause list. Learned counsel, name of the learned counsel for the respondent number 1 and 2 in the cause list.
23. I'm deeply obliged.
16th May. 16 May.
23.
Master.
Let it come at 2 p.m. Let 2 p.m. to 2 p.m.
Item number 23 to continue.
May I please?
Yes.
In this case, my lord, petitioner is holding the charge of the principal of the government higher secondary schools, my lord. But through the impugned Shokos, my lord, page 59, he has been asked to submit the NOC for procuring the, my lord, the B.Ed degree in the year 1994 for submitting the NOC. NOC, page number 59, my lord. Your Lordship, before that, page number 58, your Lordship will find a hearing has been conducted with regard to the in charge, principal in charge of Dishpur Government Higher Secondary School.
Yes.
And my lord, thereafter, your Lordship will find page 59. The explanation has been asked, my lord, that he has been asked to submit the NOC from the computing of the for procuring B.Ed degree and post-graduation degree to the undersigned within 3 days. He has submitted his reply thereafter, my lord. Page 60 and 61 is the reply, my lord. Thereafter, my lord, he has approached this honorable court. This honorable court has granted interim protection, and as a result, my lord, further process has been stayed. This issue has already been decided by your lordship in the case of Madhav Chandra Kolita, that the NOC for the purpose of, my lord, the procuring the degree is it shall not be a bar for holding the charge of the principal or headmaster, my lord. This is said. May I please? In the year 1997, my lord, he has got the certificate. And page number 47, your lordship will find the NOC from the principal or the then principal. It was taken on 26/7/1996.
Page number
47. But it was not from the inspector of schools concerned.
47.
Page 47.
But who is the competent authority to grant you permission to pursue B.Ed course?
Actually, in respect of government school is the director. And in respect of provincial schools, appointing authority is the inspector of schools.
Yes, Mr. Sharma, what?
And page number 49, you also will find, on the basis of that certificate, he has been granted in the year 1999 the incremental benefit, my lord. And page number 53, you also will find, the director has written a letter to the Guwahati University asking the authenticity of the certificate. And the reply has in the next page, page 54, from the Guwahati University.
Yes.
It's a valid certificate, man. In the year 1989, his certificate has been accepted and he has been granted the benefit out of that certificate. And the verification has been done also subsequently. But in the year 2024, this impugn shock notice has been issued.
Page number
59.
Yes.
And this honorable court has already settled this position, my lord, for issuing such types of shockos, my lord, that the authority has to come to the conclusion before that, my lord, whether the persuasion of the degree by the employee concerned has caused any prejudice to the students and the academic duties of the. There is no such ingredients. And practically, my lord, that is not also possible. In the year 1997, someone has procured the B.Ed degree, my lord. But now in the year 2024, it is not even possible for the authority to, my lord, to ascertain, to find out whether the students of that during that period had been subjected to any sufferings due to the procurement of the degrees by the concerned teacher. For that, witnesses have to be procured. Everything, materials have to be collected by taking the statements of the students or teachers of that period.
Okay. What is your stand, Mr. Sharma?
My lord, Annexus 6, page 59. This letter is outcome from the complaint raised by the Kamaleshwar Doimari, one of the incumbent, my lord. Subject is a Dispur government SS school. So, my lord, on the basis of that complaint, the department has asked him to produce the NOC. You are therefore directed to submit the NOC issued by the competent authority before pursuing your B.Ed degree and post-graduation degree of the to the undersigned within 3 days from the date of issue of this letter. And Madam, moreover, he taken the NOC from the principal, not from the inspector of his school, because inspector of his school the appointing authority.
Director.
Mm-hmm.
2020 rule. It will not. Director is the control.
So director is the appointing authority. So he has to take permission from the director. Moreover, my lord, as per rule 13 of the Assam Civil Service Conduct Rule, my lord,
no government servant, while the government service shall join or attend an examination of a recognized board or university without obtaining previous permission from the appointing authority.
That is, there is a proviso, my lord. Proviso to that rule, that is also explained by your lordship.
Where you are reading?
Assam service, my lord. Rule 30.
Provision of Rule 13.
Page number?
Here, my lord, in the judgment, page number 85, in this writ petition. my lord.
This quoted.
Rule 13, yes.
May I read, my lord? Prosecution of studies by government servants in educational institution. No government servant while the government service shall join or attend any educational institution or for the purpose of preparing himself for or shall appear at any examination of a recognized board or university without obtaining previous permission from the appointing authority, provided that the appointing authority may refuse such permission in the interest of public service on consideration that such joining or attending any educational institution or appearing at any examination may create dislocation of work or stand in any way of the efficient discharge of his duties by the government servant concerned. Permission of study leave or any other kind of leave granted for the purpose of joining or attending any educational institution shall be subject to the condition that the government servant shall not seek election to hold any elective office of in students union or other association of students except association of form for purely literary, academic or athletic pursuits.
In the said judgment, my lord, this honorable court has given the findings that, my lord, that should not be a bar for holding the charge.
So basically, my lord, regarding the NOC, that question is raised on the basis of the complaint made by the Kamaleshwar Doimari, subject teacher, Dispur Government High School.
He has made a complaint because, my lord, if I am out, he is in. That is the thing.
Okay, okay. Our Mr. Professor Learned Counsel for the Prisoner and Mr. U. Sharma, Learned Standing Counsel for the Responsible Purpose, argument concluded, order is that will pass the order.
Obliged.
Standing item 5.
Lordship has received, your lordship, as per instruction, your lordship, the suspension order has not reviewed within the time period.
Not reviewed.
Not reviewed, your lordship, 90 days.
If it is not reviewed,
Although,
then in
Lordship,
view of
I
the
would like
decision
to
of Supreme Court,
kindly-
in case of Jose Kumar Surur,
Yes, your lordship.
it has to be set aside.
And this is the bail order, your lordship.
I have annexed that one.
Okay, we'll set aside the order.
Your lordship, in the meantime, DPC may be proceed, your lordship.
Pardon?
DPC, departmental proceeding is still
DPC
pending.
will go on.
Yes,
That
your
will
lordship.
go, no problem. Obliged.
Yes.
Standing item 12.
May I please the word?
Yes.
My lord, in this case, my lord, petitioner is a teacher of an LP school, my lord. And he was convicted in a criminal case, my lord. Then he was acquitted by this honorable court, my lord. And after acquittal, my lord, he filed a representation to allow him to join his service. but he was not allowed. Then he filed a writ petition, my lord. After
Whether any departmental proceeding was initiated against you?
actually, my lord, whatever, no departmental proceeding was initiated, my lord. Then when the petitioner filed the writ petition, my lord, after the filing of the writ petition, the director passed the order, my lord, allowing him to rejoin the service, granting benefit earlier salary after releasing from the jail, my lord. Accordingly, my lord, area salary was prepared, my lord. Part of area salary was paid from the district and part of area salary was sent to the director, my lord, for approval, my lord. Then, my lord, it was no approval was given, my lord. Then petitioner filed a writ petition, my lord. Your lordship will file the writ order of the writ petition, my lord. My lord, page starts from page 40, my lord. And relevant portion, your lordship will find page 42, my lord. Second para, my lord. Third points, the learned counsel for petitioner submits that he had accepted the order of rejoining with all the conditions, and presently he is only restricting his claim for the period from the date of his acquittal to the date of his rejoining. The same was also the conditions in the order dated 23/11/2060, subsequent to which the order dated 7/3/2071 was also passed. The learned counsel has also submitted that in the meantime, the statement of area salaries of the petitioner has also been prepared by the district elementary education officer and is presently pending before the director, elementary education Assam. Sri J. Abedin, learned counsel for the elementary education department, has fairly submitted that the direction may perhaps be issued to finalize the proposal and pass necessary order of release of the area salaries of the petitioner for the period mentioned above. Considering the aforesaid contention of the learned counsel, this writ petition is disposed of directing the appropriate authority, more specifically the director, elementary education Assam, to look into the proposal forwarded by the district elementary education officer toward release of the area salaries of the petitioner for the period from so and so to so and so, which is also mentioned in the orders annexed to the writ petition. Upon such, the director shall pass necessary order for release of the salaries. The entire exercise be undertaken should be completed within period of 3 months. Thereafter, my lord, a salary was forwarded to the finance department for payment, my lord. In the meantime, Corona came, my lord, COVID, my lord. Then, my lord, subsequently, when there was no dispute regarding the entitlement of the petitioner regarding that area, then, my lord, impugned order was passed saying that he did not work, my lord. And he is not entitled, my lord. And my lord, your lordship, for a moment, my lord, kindly page 28, my lord. This is the order on the basis of which he joined his service, my lord. 28, my lord. Your lordship, last portion, my lord. Since the petitioner Hussain Ahmed Majumdar was acquitted by the Honorable High Court and disciplinary action was taken against the accused person, he is to be allowed to join his service. However, he is not entitled to back wages from the date of his arrest up to the date of his acquittal by the Honorable High Court, by order dated so and so. It was very much clear and there was no dispute regarding that part, my lord. Petitioner, when the petitioner filed the writ petition, earlier writ petition, he also claimed that that part also when he was in jail, my lord. But during the hearing, my lord, he relinquished that part, my lord, and confined his claim to that part, my lord. And accordingly, proposal was sent to the finance department. But due to if Corona had not come, my lord, other payment would have been made, my lord. Now, my lord, subsequently, my lord, new director came and passed this order, my lord. And same authority cannot review its own order, my lord. Your lordship will find page 12, page 50 onwards, my lord, impugned order, my lord.
Yes.
Proceeding. Petitioner so and so was judicial custody in connection with case number so and so, as reported by DA Silently by letter dated so and so. He was implicated in a murder case and convicted for life imprisonment on so and so. However, the Honorable High Court
acquitted him by order dated, and he was released from jail on author. After release from jail, the petitioner submitted an application to allow him to resume his service. The application has been forwarded by DIS Hailakandi with details to DE Assam for accord of necessary instruction on the matter. No communication on the matter of arrest and conviction of the petitioner from the BEO Hailakandi and headmaster and any other stakeholder was received by the directorate immediately after arrest and conviction or during the period of his judicial custody. Upon receipt of letter from DIS Hailakandi after the release of the petitioner from judicial custody, this office has issued letter so and so to for furnishing the detailed report on the matter. DIS Hailakandi has informed by letter dated so and so has reported that petitioner was receiving regular salary till the date of his conviction and was neither suspended nor terminated at the time, but due to absence in duty, salary was not paid. In the meantime, petitioner appealed before the Honorable High Court by so and so, subsequently leading to contempt petition so and so. This office order issued so and so by which the petitioner was allowed to join in his service, since being a government servant in police custody and a disciplinary action was not taken earlier the petitioner has been deemed to have been suspended with effect from so and so the date of arrest as per disciplinary and appeal rules. The period of suspension has been counted as period of service without any break. However, he is not entitled to back wages during which he is in custody till the date of his acquitted by the Honorable High Court. Accordingly, petitioner resumes his service from 7 to. My lord, for a moment, my lord. Now they are taking a plea that petitioner has resumed his service. My lord, after coming from the jail, my lord, he immediately approached the authorities to allow him to resume. They did not allow the plea. Then the petitioner filed read petition. Then petitioner filed contempt petition. One contempt petitioner was pending, my lord. Then they passed the order and allowing him to resume his duty with the condition that he will be entitled back wages after the date of acquittal, after the date of release from jail, my lord. And now they are saying that petitioner did not do his duty, my lord. They did not allow the petitioner, my lord. Petitioner was, after coming from the jail, he was very much pursuing to enable him to join the duty, my lord. And it was not at all a matter whether he is entitled that part or not, my lord. Now, my lord, the director, my lord, pass next page, my lord. Page 51, my lord. The petitioner appeared before the Honorable for release of it during the period after he was acquitted by court. He rejoined his service. Honorable High Court, in its order dated past tender, directed the appropriate authority, more specifically DA, to look into the proposal submitted toward release of area salary of the petitioner for the period from so and so. So upon such examination, DE Assam will pass necessary order for release. This office had communicated to DEO Hailakandi to submit fresh proposal in respect of area salary of the petitioner as per prescribed format by letter to so and so. The DEO has submitted the fresh proposal along with relevant statements, letters, so and so, so and so. In the meantime, the petition WPC so and so led to contempt petition so and so. The directorate level committee constituted by order dated so and so had reviewed the aspect of the area proposal in the light of the Honorable High Court order. The committee has stated that the petitioner is liable to receive area salary on the ground of regularization of service by DEO order dated so and so and based on other relevant records. Further, the committee stated that as per report of Hailakandi, since the petitioner is holding a permanent post, necessary for creation of a permanent post may not arise for release of the area salary. Further, it is also reported that departmental proceeding had been completed following all norms and guidelines and the period of service has been regularized. Senior Finance and Accounts Officer of this day, after review of the proposal and order, stated that the Honorable High Court's order to allow area salary with effect from so and so to so and so is the period during when the petitioner was not performing his duties. Petitioner was in judicial custody from 23/11/2000 to 5/4/2012 and he rejoined the school on 7/11/2017. Therefore, the petitioner was absent in duty with effect from 23/11/2017 to 7/11/2017 as per records of DEO and DIS Hailakandi and other relevant documents. The period of suspension counted as period of service without break in the DE order dated may be considered for pensionary benefits as it means and may not be entitled to area salary as the petitioner was not in duty during the period of claim of arrear salary.
So is there any document to show that immediately after acquittal by this court? Then coming out from the jail, you have approached the authority
Yes,
by
my lord.
filing an application?
Yes, my lord. Your lordship will find the initial court order, my lord. Your lordship will find page 23, my lord. Start from page 22, relevant page 23, my lord.
The date of representation is 25/5/2012.
Yes.
Is it?
Yes, my lord.
So now your claim is only for the period 25/5/2012 till
My lord, my claim,
2017.
my claim is that, my lord, my claim is on the basis of page 28, my lord, because page 28, my lord, made it clear, my lord, how much I am entitled and how much I am not entitled, my lord. Last portion. Order. Since the petitioner Hussain Ahmad Majumdar was acquitted by the Honorable High Court and disciplinary action was taken against the accused person, he is to be allowed to join in his service. However, he is not entitled to back wages from the date of his arrest up to the date of his acquittal by the Honorable High Court by order dated 3/4/2012, my lord. He was released from jail, my lord, on 5/4, my lord. And he is entitled as per that order, my lord, from 5/4/2013, my lord, 2013 to 6/4/2012 to February 2016, my lord. 6/4/2012 to February 2016, my lord. After February 2016, that part of arrear salary was already paid to the petitioner by the district authorities, my lord.
And on what basis this impugned order was passed?
My lord, impugned order was passed actually by misinterpreting the judgment of this court, my lord. My lord, this court, my lord, page 12, my lord. Last portion.
No. After passing this order, dated 23rd November 2016, why they have reopened the file again?
Yes, my lord. After 2016, my lord, a statement of area salary was prepared and part of area salary was paid from the district and another part was sent to the director for approval, my lord. When it was lying before the director without any decision, my lord, then the petitioner approached this court and this order was passed, page 41, my lord, directing the director to release the area part, my lord. But it was, since it was written as like, my lord, considering the aforesaid contention of the Learned Council, this writ petition is disposed of directing the appropriate authority, more particular director of elect, to look into the proposal forwarded. Since the word is written, look into the proposal, my lord, now they reviewed this order. Reviewed their own order, my lord, and passed the impugned order, my lord. Otherwise, there was a entitlement of the petitioner was very clear, my lord.
Yes, Mr. Katonier, what is your stand?
During that period, my lord, he was not in service, my lord. He was not working. Since he was not in,
But you have not allowed him to join?
my lord, during that period, my lord, ultimately from 2012 to 2016, he was not in service. Pursuant to litigation, he was allowed to join in
No,
service.
they have, he had filed one representation, but he was not allowed to join.
That representation is not connected with this restriction, my lord.
That is reflected in the order
My
of
lord,
this court.
in the order I have seen it, my lord.
Hmm.
But since he was not in service during that period, in the principle of no work, no pay, my lord, that principle is
No, no.
applicable in.
Having not allowed to join him. Now, can you take succession that he was not in work for that period?
In similar cases, my lord, I have came across some similar cases, my lord. Here it is if the concerned person is not joined in service during that period after his acquittal from service.
No, who is
So
responsible for the same?
that in
The
fact, my lord,
petitioner or you? So do we ignore the observation made by this court in the writ petition? Other writ petition?
the earlier petition, my lord.
Yes.
Case 41, my lord.
Hmm.
The case of the petitioner is that after such acquittal, he has filed a representation dated so and so to the authorities to allow him to rejoin in his service with all service benefit. As no action was taken in the petitioner filed, so and so was disposed of, highlighted so and so directly to the concerned representative within a month. Consequently, the respondent had passed an order. So ultimately, he was allowed to join in the year 2016. So while his proposal for area salary was considered pursuant to this order, my lord, the principle of no pay has been applied.
That's all right, but can I invoke that principle?
In that regard, my lord,
Where is that other judgment?
yes, my lord, I would like to rely on these two judgments.
No. You have referred another judgment where the date of representation.
Page 41, page 14. In the second round of litigation, my lord.
My lord, in the page 23, my lord.
Page 23.
23 is the first round of litigation. In second round of litigation also, that date was mentioned, my lord.
Yes, this 25/5/2012.
25/5/2012, my lord. My lord, one more thing, my lord. When the earlier writ petition was disposed of by order dated 23/5/2014, my lord, your lordship will find page 26, my lord. Third paragraph, my lord. In the aforesaid background, I am of the.
Yes, sir.
Then also they did not pass any order leading to filing the contempt petition, my lord. When contempt petition was filed, then, my lord, they allowed him to resume his duty.
Is that a contempt petition part of this writ petition?
That contempt petition is not part of writ petition, my lord.
Whether the order is available?
But it is reflected in the annexure 23, annexure 3, my lord.
Page number?
Page 28, my lord. Peruse the report submitted by letter dated court case WPC so and so and.
Okay. Any other point, Mr. Katonian?
Regarding factual aspect, there is no dispute, my lord. Whatever related, there is no dispute. Regarding the law point, I would like to rely on.
That's all right, but whether that principle, no work, no pay is applicable here.
In similar circumstances, my lord, regarding acquittal, my lord, these two judgment has been pronounced by this, one by this honorable court, my lord, and one by the honorable Supreme Court, my lord. In both judgment, my lord, paragraph 7.
My lord, one more point, my lord, one more submission.
Yes.
as the, in first one is my lord 2005-8 SCC, my lord.
Yes.
Yes, my lord. As the factual position noted clearly indicates the appellant was not in actual service. Paragraph 7, my lord. For the period he was in custody, merely because there has been an acquittal does not automatically entitle him to get salary for the period concerned. This is more so on the logic of no work, no pay. It is to be noted that the appellant was terminated from the service because of the conviction. Effect of some same does not get diluted because of subsequent acquittal for the purpose of counting service.
Mr. Katoniar, his claim is not for the period in which he was in judicial custody. So that is what has been emphasized in this paragraph number 7. His claim is after his acquittal and coming out from jail, he filed on representation to you for allowing him to join in service, but he was not allowed. Whether this judgment will help you?
My lord. One thing is that, my lord, admittedly, during that period, he was not in service. He was not in work, my lord. So since there was the principle of no work, no pay will be applicable, my lord.
Okay. Third, Mr. A.H. M.R. Sodore, learned counsel for the petitioner, and Mr. N.J. Katoniar, learned counsel for the respondent of the case, standing counsel for the respondent of the case. Argument concluded, order is out.
Deep.
Item 24.
May it please, Lord. The petitioner has been serving as director of Delaware University of Technology, my lord, since 1/11/2012, almost, my lord, last 13 years. Now, in terms of the AICT notification dated 22/1/2010, my lord, he is required to get pay scale of that particular post, and his service is required to be extended up to the age of 65 years. Now, the university did not do anything. Now, in the meantime, my lord, I'll be retiring at the age of, my lord, 60. That is on 21/5. Now, my learned friend, still, if you want to take time for filing affidavit,
Will give me just 10 days time, madam. I've sent it for vetting and signing. Comes back, we'll have the argument done, madam.
Will it come before his retirement?
Madam, I'm asking for 10 days. We'll do it on 10 days. The
I hope
instructions
you
came
will
in
not
March.
try to get my petition to be infructuous.
So
my
that
lord,
is
I-
what
I
happens. If
hope
if
my
he's
learned-
entitled to a pay scale, he'll get it today, tomorrow, he'll get his retirement if it's on the
Let him take
basis of
7
pay
days
scale.
time, and in the meantime, he can file this.
Okay.
So
My lord, my predicament is that I'll be retiring on 21/5.
the retirement.
Third, Mr. S. Dotto, learned senior counsel assisted by Ms. Learned counsel for the petitioner, Mr. Mazumdar, learned standing counsel for the respondent. Press for granting him 10 days time to file affidavit. However, Mr. Mazumdar is granted 7 days time to file his affidavit in opposition. Place the matter on, okay, fix it.
On 9th May.
Can it be on 5th, my lord?
Monday পড়িব স্যার।
Okay,
First,
5th,
first,
first, that will be nice. Obliged.
25.
Thank you.
May please, your lordship. My lord, the petitioner is the senior tisser than my lord, respondent number 4. But my lord, the impugn order, my lord, kindly see page, my lord, page 33 and 34. In charge principal was given to the, my lord, inspector of school, and academic principal, in charge was given to the, my lord, junior person, my lord. Last time, honorable court directed to file affidavit to the respondent, but till date no affidavit file. Then on, my lord, kindly see 26/3/25, the respondent was directed to obtain instruction why the, my lord, junior person was allowed to act as academic in charge, but no response has been filed, my lord, till date. And otherwise, the case is covered by my lord Mosumi Sohori and your lordship judgment also, Madhav Chandra Kolita, and item 23 of my lord, today's list, my lord. Kindly see the list of seniority, my lord. Page, my lord, page my lord 24. Starting from page 23.
Mr. Fusika, are you really interested to file the affidavit?
But I've received the instruction today, my lord. In fact, my lord, the instruction which I have received, my lord, it says, my lord, that the academic in charge, there is no such post, my lord. It is just a temporary arrangement that has been done. And there is no financial benefit also given to the person who holds an academic in charge. And the financial power is being exercised by the inspector of school. Page 33 and 34. 34, the director has, after the earlier principal has retired, my lord, on 31st of January 2024. The inspector of school is allowed to act as the in charge of the principal of so-and-so school with financial power to draw and disburse the salary of the staff of the school in addition to his normal duties under FR 49C by Jinnat Subhani, principal in charge, who will retire on 31st of January 2024. So it is the inspector of school who has been appointed as the principal in charge. Now the page 33.
Yes.
33, my lord. The one teacher, Khurshedul Islam, is a postgraduate teacher of Borkandar People's Academy High Secondary School. He is allowed to look after the academic affairs as an academic in charge in addition to his normal duties. One of the instruction which I have placed, that their allegation is, well, that the junior most has been given as a given the charge of a principal. But whereas, well, the principal, the inspector of school is given the charge as a principal. And the inspector to look after the academic affairs of the school, because school has to run, because inspector sits in a different office. So to look after the academic affairs, this person has been given the charge.
Why the petitioner is deprived of?
That nothing has been said.
Petitioner is my lord, page my lord 24. Petitioner serial number 2. He was appointed in 1995.
I'll bring this instruction on affidavit. I'll bring this instruction on affidavit.
Whether this will change any position. Why the post of academic advisor?
No.
Academic in charge.
Academic in charge.
Why the petitioner was not interested?
No, that the instruction is silent.
There is
What
no
is the
mention
reason?
in the my lord impugn order, madam. No, nothing has been mentioned in the impugn order, madam.
The instruction simply says, well, it's a purely temporary arrangement done.
Maybe it may be temporary. Why
I'll
the
bring this
senior
on
is
affidavit.
deprived of?
My lord.
Why the senior is deprived of?
That my lord, I have to take instruction, my lord.
We have to take instruction.
Otherwise, my lord, law has already settled that my lord, senior person has been my lord, take as in charge principal, my lord. Because my lord, the inspector of school, if it hand over the in charge principal, my lord, the academic will face, my lord.
So let it be on next Tuesday.
My lord.
I'll take instruction on that.
My lord.
Mr. M. Islam, learned counsel to the petitioner, and Mr. B. Kosik, learned extending counsel to the respondent of the case. Mr. Kosik has produced the written instruction received by him from the inspector of the school, DDC to. But we appointed query of this court, Mr. Kosik could not explain as to why the petitioner herein was not interested with the academic inserts of the school, though he is the senior most teacher of the said school. Mr. Kosik submits that he may be granted some time to obtain instruction. Here is allowed, recess less than next Wednesday, or no, Tuesday. the letter produced before the court today shall be part of the report.
Highly oblige your lordship.
26.
May I please? In this case, my lord, the state respondent has deducted the salary of 1 day by
Affidavit has been sent for waiting, my lord. In 26.
When it will be available.
Within a week, like, after a week, let it be after a week.
Partners are put as the Barnet Council for the petitioner and Mr. Kosik, Barnet Standing Council for the respondent on purpose. Mr. Kosik submits that he has prepared the affidavit and sent it for vetting. And a press for listing the matter after 1 week. There is a law, this is a list after 1 week.
27.
My lord, in this case, my lord, the petitioner was serving as a block accountant, my lord, under the Sarva Shiksha Abhijan mission, my lord, and in the office of the block mission coordinator. What happened, my lord? The petitioner took leave, my lord. He has submitted application for leave on my lord, page number 24. He has applied for leave for treatment. And my lord, after his leave, my lord, he has also submitted another application, page number 27. It was received on 2/5/2017 by the authority to resume with a prayer to allow him to resume his duties. But what happened, my lord? The authority concerned, my lord, though accepted and acknowledged the receipt of this application, my lord, did not release his salary, and he was shown to be absent in the duty. Was shown to be absent in the duty, and ultimately, my lord, a show cause notice was issued, and he has submitted replies to the show cause notice. And thereafter, the report has been forwarded to the office of the mission director, my lord, for taking a decision with regard to allowing him to resume his duties. And petitioner is the only son of his parents, my lord. Both of them expired within one month duration. Both his parents expired with 1 month duration, my lord, during that period when he took the leave, my lord, due to their illness. And he is unmarried and the only person in his he himself is the family, my lord, now.
What is the period for which he remain absent?
My lord, actually, my lord, he submitted the application on 17/4/2017, asking for leave, my lord, for treatment of his parents. And thereafter, my lord, he has submitted, your lordship will find page number 26. He has submitted his application to resume his duties, my lord. '27 is the handwritten copy, which was received on 2/5/2017. And as no action has been taken, my lord, he has submitted another application on 12/7/2017, asking for granting of approval of and rejoining, well, again. Yes, again thereafter, my lord, on.
What kind of leave you have availed during that period?
Pardon, lordship?
What kind of leave you have applied for and availed?
My lord, he has applied for, my lord, early, I think, my lord, as per office order, my lord, these types of employees are entitled to some leave. Page number 22 is the office order, which circular, which provides, my lord, various categories of leaves to these types of employees under Sarva Shiksha. He has applied as he is going to medical leave, medical treatment, my lord.
Whether that kind of leave is provided in this
lordships.
whether that kind of leave is provided in this office order.
Yes,
Medical-
and the office order, my lord, provides, my lord, special annual leave for 15 days. Then medical leave for 15 days. This page 22, my lord. These are there.
Okay.
Casual leave for 12 days. The Lordship will find at page number 34, after his joining, my lord, he has performed the duties also. The duty sheet for 2 months I have annexed.
Page number 30.
34. For the month of August 2017 and November up to November 2018, my lord. But these duties have not been acknowledged by the concerned block officer.
Mr. Nayak, what is your stand?
They have submitted, they filed their affidavit, my lord, or they have acknowledged this aspect also.
Lordship, petitioner was contractual employee under SSA law. These contracts are for 1 year period. Now, during the period, Lordship, he was absent from duty, Lordship. In the meantime, his contract expired. Thereafter, Lordship, his contract was never renewed. That is the basic reason. He was also issued a show cause notice on 24/5/2023. That is at page 57 of the petition. And his reply is at page 58. And if your Lordship goes through this reply, Lordship will see he himself explained why he was absent from 2017 to 2022. Now, a person, Lordship, who is absent from 2017 to 2022, can he again place an application just by saying that this was my problem, I could not join at that period of time? Please allow me to rejoin. That is not possible, Lordship. His contract expired in the year 2017 itself. And that is, thereafter, his contract was never renewed. That is the basic reason we have taken, Lordship. And in this regard, Lordship, we have also filed one affidavit, Lordship. And if the petitioner is not intending to file any reply, Lordship, then Lordship will take up this matter for hearing, Lordship, for final disposal. If he is not filing any reply.
Yes, Mr. Professor.
The Lordship can dispose of, my lord, because the shock cause notice proceeding is initiated by the department, my lord, SSA, my lord. Shock cause has been issued, reply has been submitted. Final decision they have to take, my lord. Your Lordship may dispose of with a direction to the authorities of the SSA to take a final decision in the proceedings initiated by them, my lord. Unless they take the final call, my lord, and the matter is pending, it will not come to the end, my lord.
Yes.
That will be done, but that will not create any right in his favor, Lordship. The Lordship will only say authority will decide without going into the merit of the case. That much is agreed, Lord.
Okay, then we will pass the order.
Yes, sir.
Last.
Item 27. Sorry, 28. Item 28.
May it please your Lordship. In this case, your Lordship may kindly see, my lord, the order dated 4th of December, your Lordship, 2024. Your Lordship may kindly see order dated 4/12 of 2024. Despite that order, your Lordship, no affidavit has been filed in this case, your Lord. So my submission would be that, my lord, let the rule be issued and matter be listed, my lord, for hearing next week or after some days, my lord. Preferably next.
But I have received certain instruction, my lord, but I guess this will not be sufficient to file affidavit, my lord. That's why, kindly give me 3 weeks time, my lord. I'll get updated instruction and file the affidavit.
That particular order was issued, my lord, for the purpose of issue of the interim order, your lordship. But after, despite passing of so many months, your lordship, they did not do anything. So let the entire matter be heard, your lordship, let it come on 8th or 15th, your lordship.
No, can it
That-
be?
that's
And in the meantime, they will file their affidavit if they so like.
But issuing of rule will hamper the selection process, my lord, because the post is still to be filled up. Although, my lord, one candidate has been selected, but director is yet to take a decision, and my lord, there is a my lord, judgment of this coordinate bench, my lord, which says that these kind of matters are actually premature, where the director is still yet to take my lord, a call.
My lord, in this case, my lord, the respondent number 8 has been selected for appointment to the post of an assistant professor in a college, your lordship. Now, from the comparative statement or other, my lord, certificates I have annexed in respect of respondent number 8, your lordship will find the respondent number, my lord, she scored the lowest marks in the selection process. She did not have the requisite qualification, my lord. She passed MA by distance mode, my lord, as an off-campus candidate. That is not permissible as per the various judgment of our court itself, your lord. Secondly, your lordship will find she did not have any uniform good academic record, your lordship. She passed matriculation, your lordship, 3rd division, higher secondary, 3rd division, BA, 2nd class, MA off campus, and then she has my lord, obtained and PhD degree even, your lordship. Now, advertisement said, my lord, she must have a PRCD, my lord, certificate permanent. That is also not there, your lord. Now, violating all this, my lord, criteria or norms for appointment to that particular post, my lord, she has been selected for appointment. So what more he will, my lord, submit by his affidavit, I do not know. But still then, if your lordship likes, my lord, he may be given some time. And let it come on 15th, your lordship. I will be here up to 15th, my lord. Today some difficulty, my lord. Today some difficulty.
Okay. Heard Mr.
Andhor,
Andor, learned counsel for the petitioner, and Mr.
Yes,
Das, learned standing counsel for the higher education department. Mr. Das submits that he has received some instruction, but the same is not sufficient for filing an affidavit in opposition. And if there is for granting him some time to file, to obtain
Updated instruction, my lord,
updated
and file
instruction and to file an affidavit. There is allowed to list the matter on.
On 20, 20.
Let it come on 8th, let us see.
8th of May.
8th of May, your lord.
8th of May.
Yes, 8th of May.
Mr. Das, okay, 8th of May. Places shall list the matter accordingly on 8th of May. The instruction plus on the plus before the court today shall be part of the record.
29.
May you please, your lordship. Lordship, in this matter, respondent authorities had to file their affidavit, but they are not filing their affidavit. It's a matter of pension, lordship. There is extreme urgency. Matter is repeatedly listing, but they are denying it. Kindly fix the matter next day.
This matter pertains to whether, my lord, the petitioner would be covered under the new pension rules scheme or the old pension, my lord, 1969. Petitioner is, my lord, relying, my lord, on the basis of judgment, my lord, that Purnima Hore decision, my lord, where, my lord, this honorable court, my lord, have extended the benefit of new pension scheme, my lord, to the category of stipendiary teachers. Now, the petitioners here claim to be stipendiary teacher, and all other category of teachers have been excluded therein. Now, to that extent, my lord, after Purnima Hore decision was pronounced, my lord, the finance department had called for, my lord, inputs from all the department, including education department. The education department has sent a list of 303 number, 303, my lord, number of persons who are, my lord, stipendiary teachers. And, my lord, the benefits have been extended accordingly on examination. Name of the petitioner is not found in that list. That is my instruction. affidavit may not be required. my lord. Lordship may retain this as a part of the record.
যদি stipend যদি পায়, এতিয়া যদি stipend নাই পোৱা, তেতিয়াহ'লে সেইটো তোমালোকে ক'বা।
So when the petitioner was appointed,
Appointment order, my lord, that lordship will find my lord at page 20. Page 20, that is in the year 95. Page 20, my lord, this states, my lord, that the petitioner will initially get a monthly stipend of rupees 900 per month. Then she will have to clear some examinations. Then, my lord, if lordship may be pleased to come to, my lord, page 22. Page 22. Lordship will find. My lord, this is a order dated 11th of November 2002. Now, the petitioner has been posted, my lord, against existing vacancy, my lord. He has been posted as an existing vacancy,
on
my lord, on 11/11/2002. Page 22, my lord, down
his
below.
service was
also-
regularized.
Yeah, regularized, but against existing vacancy, my lord. Now, this regularization order is passed by the inspector, my lord. Now, whether this regularization order is a regularization order in accordance with law, my lord.
No, that is not the subject matter.
Subject matter, yes, yes. Now, my lord, the issue is whether if the petitioner establishes her case that she is a stipendiary teacher, immediately she will come within the ambit of paragraph paragraph 118. No, she will be entitled to the benefit. She will be entitled to the benefit of all pension rules in terms of paragraph 118 pronounced, my lord, in the Purnima Hore decision. Now, whether she is a stipendiary teacher or not, that has to be clarified, my lord, by the education department. Because I am not the employer. But at the end of the day, my lord, we will have to sanction and give approval to the, my lord, for extending the benefit of all pension. But the inputs, all the data has to be given to us by the employer. To that extent, my lord, we have received the list from the education department already, my lord, of 303 teachers, 303. There, the name of the petitioner doesn't figure. That much, my
No, is it your submission that only the stipendiary teachers whose name is incorporated in the list of 303 teachers will entitled to whole pension scheme?
Yes, 303 teachers, and over and above that, if some other persons are also sought to be given, my lord, the benefit of, my lord, the old pension scheme as per paragraph 118 of Purnima Hore decision, then the data or the proposal will have to come from the education department, because I am not the employer. On verification, on examination, I am satisfied.
Mr. Porpoisary, you have submitted that only those whose names figured in the 303 list
303 that is already given. Now more and more people are coming, my lord. 303, my lord, after Purnima Hore decision was, my lord, pronounced. Thereafter.
Forget about Punima Horo decision.
Yes.
Whether being a regular employee, she is not entitled to pension, he or she is not entitled to pension
If she,
under the police scheme.
yes, if he or she, my lord, they can establish that he or she is a stipended teacher, that much. Other category of teachers are not entitled. This is what Purnima Hore says. Drop teachers not entitled. Access teachers not entitled. Teachers appointed under OBB scheme not entitled. Everybody has been given a go by. That Purnima Hore, this, my lord, the judgment has been put to challenge before the Honorable Division Bench. Division Bench has not interfered till today. So Purnima Hore decision stands as on today. And the stipendary teacher is definitely entitled to, but which he will, or the petitioner will have to establish. And it has to be corroborated or admitted, my lord, by the education department, the employer. That much. So we will take a call at the end of the chain. We will take a call at the end of the chain, my lord. At the end of the chain.
I have not received any instruction regarding whether she is stipendary teacher eligible for this pension or not. Malab, some time will be granted, I will bring the instruction. She may not be entitled, Malab, she may not.
Why?
She may not have the required qualification because she have to pass the JBT.
If she has not passed that examination, how you have regularized her service?
Within the stipulated time, Malab. Let us take instruction, Malab. The reason why she is not.
No, having regularized her service in the year 2002.
My lord.
Now, can you say that she is not entitled to pension under the old scheme?
Let us verify all these things, my lord. I'll bring the accordingly.
So when the verification process will come to an end?
Still is on, my lord. There are so many petitioners has come there.
Maybe.
Claiming as a stipend teacher, my lord.
So when the petitioner retires?
Going to retire this year, lordship.
Petitioner has not retired. In the affidavit, the age of the petitioner is 58 years.
Okay, so she is still in service. Okay.
Basically,
Let the instruction come.
Basically, my lord, this is a petition claiming benefits under Purnima Hore decision. We are not denying. Only thing is that she will have to establish. And they will have to admit that much.
Third is your good name, please.
M. Bora, lordship.
M.
Bora, on behalf
Bora.
of Mr. S.
Court of
Chaudhary.
Appeal and Mr. Corporation, Lord, it's in council, finance department, and Mr. Bora from
Elementary education department.
elementary education department. Mr. Bora submits that he has not received any instruction and price for granting in some time. Here is law. On the other hand, Mr. Corporation has produced his written instruction. And you are not going to file any application.
This may be kept as a part of the record, but tomorrow.
And submits the said instruction will be part of the record. Accordingly, it is provided that the instructions so flash before the court today shall be part of the record. List the matter after
2 weeks.
After 2 weeks. After.
Lordship may.
Mark that instruction with any letter, letter X or letter Y, that can be reflected. Then it will not be misplaced, my lord. Sometimes.
Okay, yes, like X.
And so.
Lordship, date may be fixed, lordship.
On 20, 31.
With legal lordships.
Yes.
In this case, my lord, petitioner was appointed as a deputy inspector, my lord, on 1/2/2025. But because of he is going to retire within a period of 8 months, my lord, and he was suffering. Then he approached the honorable department and to forgo the his promotion, my lord. Then he filed representation, my lord. When respondent did not pay any heed to it, we approached this honorable court, my lord.
and Honorable Court pass an order to dispose of the repentation, but they have disposed of the repentation. Again, they have filed, they have issued speaking order. That is, Lordship, kindly peruse page 34. Before that, Lordship, kindly peruse page 26, that the pair for exam from the promotion, my lord, as for the post of Deputy Inspector, my lord. Lordship got it. Page
Yes.
26, Annex 4, my lord.
Annex 4, yes.
Yes, my lord. With due respect and humble submission, I beg to state that I have been rendering my services as BEO in Lahori Ghat Education Block in the district of Morigaon, Assam, since 12/2/2024 to till date. That, sir, from the reliable source, I have come to know that BEO will be promotion to the post of Deputy Inspector of School within a short period of time. That, sir, I am suffering from various diseases and my service period of left for only 1 year. Now it is 8 months, my lord. And I have 3 numbers of underage daughters, and there is no any one person available to look up my family except me. So kindly exempt me from the promotion, my lord. But they did not any pay to hit, my lord. Then I approached this honorable court, and honorable court passed an order, my lord. That is, it starts 29.
29.
29, my lord. It starts from 29. And the last portion is in view of the consent of the parties. Page 30. Para 5, my lord. In view of the consent of the parties, the Secretary to the Government of Assam Department of School Education is directed to take the decision on the petitioner's representation dated 4/2/2025 within a period of 1 month from today. But the petitioner shall service the copy of the order along with. Then after submitted all the documents, my lord, again they have filed another speaking order, my lord. Against that order I have come. And I got interim order also, my lord.
Annexure 9 is the.
Annexure 9 and page 84.
34.
34, my lord. They did not utter anything regarding the retirement, my lord, and that the person who has been suffering, my lord, they did not utter anything. That they said that the grounds of his child who is appearing HS examination para 5, my lord, is no longer available at the said exam, has already been got over on 3/3/2025. Again, they have directed the petitioner to go to the Majuli, my lord. And there is a government notification also. It is with him.
On the last occasion, this honorable court asked whether there is any law regarding foregoing of promotion. This is the office from which.
May I place one submission? There are lots of decision, my lord.
This is
Lots
the
of
office
decision.
from issued by the personnel department. My lord, which governs that refusal of promotion and the fixation of seniority if refused. These are the conditions, my lord. Your lordship will find second paragraph. Second paragraph, my lord will find after careful consideration of all aspects, it has been decided to make the following policies on refusal of promotion by a government servant and fixation of seniority thereafter. When a government servant does not want to accept a promotion which might be offered to him based on his seniority rate or merit cum seniority, he make a written request before the departmental promotion committee meeting is held that he may not be promoted, and request will be examined by the appointing authority, taking relevant aspects into consideration. If the reasons adduced for refusal to promotion are acceptable to the appointing authority, so this is the discretion given to the appointing authority, and the request is formally accepted by the appointing authority, the next eligible officer of the same category in the zone of consideration may be promoted. When a government servant does not want to accept a promotion which is offered to him as per the recommendation of the selection committee, departmental committee, he may make a written request that he may not be promoted and his request will be examined by the appointing authority, taking relevant aspect into consideration. If the reasons adduced for refusal to promotion are acceptable to the appointing authority, a review DPC selection meeting will be held at the earliest to recommend an eligible officer of the same category from the revised zone of consideration. No fresh offer of promotion would be issued to the officer who refuses promotion during the last select year in which he opted out from being promoted. On
So,
the,
Mr. Kosak, there is an office memorandum
that's,
covering this issue.
yes.
My lord, in
And
this
that,
case, my lord,
on a request being made for refusing promotion,
Hmm.
the appointing authority has to see whether the reasons though that has been expressed, whether these are justified or not. Here in this speaking order, my lord, of course, the one reason uh, the appointing authority has dealt with is that the examination is over. Apparently, my lord, the other two reasons, because there is no discussion with regard to that,
Yes,
the health and her and the retirement of the retirement.
short time of
Retirement
retirement.
also may not be a very plausible reason for refusing it, but health could have taken
No, there is
for
an
consideration.
for retirement also. My lord, in my petition, I have annexed the person who has already been forgot in the same year. That is annexer 54, page 54, annexer 2, annexer 11, my lord. I have shown that some of the person has already been foregoing promotion, my lord. That is,
There's no
that
dispute,
is
my lord.
to-
There is a provision for foregoing promotion.
Hmm.
Your lordship will kindly see the speaking order last paragraph for a moment. Page 34. It is
But
to be noted that the post of district deputy inspector of school in a district is a very essential and indispensable in enhancing and maintaining the quality of education and monitoring of the school. Hence, in the interest of public, particularly students, the representation and the ground stated therein cannot be accepted by the Department of School Education. So the reasons which has been given for refusing the promotion has been weighed with the public interest. So
So whether while passing this impugned order, you have taken note of this office member?
no,
no.
doesn't seem so from the order.
Does not seem so.
Mm.
So being the secretary of the department, he has ignored this office memorandum.
Yes.
Yes.
So why should we say, should we not set aside the impugned order?
And remand it back to the secretary to take into consideration, my lord, in terms of the office memorandum.
In the meantime, my lord, the impugned order may be set aside, my lord. Otherwise, too. Because the petitioner is suffering, my lord. I have annexed the Fortis, some documents from Fortis and
In fact, if I may say so, my lord, the last paragraph which I read it, my lord, that for the public interest, that has also been taken care of in the office memorandum, my lord. Immediately when this in second serial number 2. A review DPC selection meeting will be held at the earliest to recommend an eligible officer of the same category from the revised zone of consideration. To replace the petitioner, the review DPC is to be conducted at the earliest. Your lordship may relegate it back to the secretary to take note of this office memorandum and take a decision. More particularly, the taking into consideration the other two grounds which have.
Okay. Ms. K. Devi, learned counsel for the petitioner, and Mr. P. Kosak, learned serving counsel for the respondent for this. Person to order of this court.
No, we did it. After the did it.
So, where is that order by which you have been asked to apply an instruction? 21.3.
The last order. 21.3.
20.
Okay, person to order of this court dated 21/3/2025. Mr. B. Kosik, Learned Counsel for the Standing Counsel for the Respondent Authorities has obtained instruction and produced an office memorandum before this court. Office memorandum dated 31st of May 2024 before this court. Dealing with the issue of refusal of promotion and fixation of seniority thereafter. And to appointed query of this court as to whether the authority concerned while passing the interim order dated 6/3/2025 has taken note of the aforesaid office memorandum. Mr. Kosik submits that the perusal of the interim order does not indicate that the said office memorandum was taken note of by the respondent authority. Then as such, Mr. Kosik submits that the matter may be relegated to the respondent authority to consider the case of the petitioner in the light of the office memorandum dated 31st of May 2024. Ms. K. Devil, Learned Counsel for the petitioner, submits that she has no objection in the event of relegating the matter to the respondent authority to reconsider the same in the light of the office memorandum. But she submits that the interim order dated 6/3/2025 may be set aside. Having heard the submission of Learned Counsel for both the parties, I have carefully gone through the petition and the documents placed on record and also perused the interim order dated 6/3/2025 and the office memorandum dated 31 May 2024, produced by Mr. Kosik, Learned Counsel for the respondent authorities. The perusal of the interim order dated 6/3/2025 indicates that in the said order, the office memorandum dated 31st of May 2024 has not taken into account while considering the case of the petitioner. We are taking note of the aforesaid aspect and also the submission of Learned Counsel for both the parties. Interim order dated 6/3/2025 stands set aside and closed, and the matter relegated to the respondent authorities to reconsider the same. Reconsider the case of the petitioner in the light of the office memorandum dated 31st of May 2024. In terms of about this disposal.
Highly obliged.
From variance 49.
Thirty-two also part had, my lord. 32 is also part had. 32 is also part had. 32.
After this, 2 matters we will take it up. We'll take it up. Yes, Mr.
Yes, my lord, I have gone through the, my lord, CD part also, my lord. My lord, that is the only, my lord, there is section 50 notices. My lord, there is the no elaborately not mentioned the ground, my. In both the matters, my.
So where is the decision of the Supreme Court?
My lord, on the last occasion, I have placed lordship. Lordship, once again, I am placing.
No, I am asking about the decision of the Supreme Court.
Lordship may kindly take up the judgment of B.N. Kumar, lordship. It is the lordship. Paragraph number 14. My lord, got it. Paragraph number 14, Lordship. Thus, the requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22.
Paragraph number
14, Lordship. 1-4.
in which judgment?
Vihan Kumar, Lordship. It starts with Lordship, thus the requirement of informing. My lord, got it.
Yes.
Thus the requirement of informing the person arrested
Okay,
of.
all right, all right.
Yes. And Lordship, in another judgment, Lordship, that is Probit Prakashita, Lordship, paragraph number 29, 30, and 31.
Paragraph number
29, 30, and 31, Lordship. The language used in Article 21, 22(1), it starts with Lordship.
So, this decision Honorable Supreme Court in the case of Bihan Kumar and in the case of Madhur Pukeso has not been complied with by the IO at the time of
There is,
arrest.
my lord, the notice was there, but that is not elaborately mentioned, my lord. So you have been arrested, the language is like that, my lord, in connection of this case. But that elaboration part, I didn't include, not elaborately.
Where is that
My lord, that I have flag mark, my lord.
no, no,
Lordship, may kindly-
in the
My lord, in my lord.
In my additional affidavit, Lordship.
page number
Page number, Lordship, 66, 65, and 66, Lordship. Page number 65 is the arrest memo, Lordship. Name of the petitioner is there, and then dated time, and then signature, and Lordship.
both the cases are arising out of the same
Arising out
FIR.
of the same FIR, my lord. Arising out of the. I don't only by one
Your good name, please.
humble.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner and also learned counsel for the accused and also heard Mr. Oisho, learned additional duty for the respondent. His petition under section 439 C is preferred for 483 of the BNSS 2023 is prepared by the accused, namely Abdul Khair Mohammed Siddiq, who has been languishing in Jalabad since 6/5/2023 in connection with special landed case number 43 of 2023 arising out of Karimganj case number 334 of 2023 under section 41C, 25, 29 and the case act for grant of bail. It is to be noted here that this is the third or fourth application. Third or fourth bail application.
Bail application, earlier rejected, how many times?
Lordship once.
Second bail application.
Second bail application,
This is
Lordship.
the second bail application. Preferred by the accused and the earlier bail application being the number 1161 of 2024 was this.
Page number
by this court
57.
by order dated 13/8/2024. Then this petition is preferred on the ground that while causing arrest of the accused, IO has not complied with the provision of 50A of the said cell. And the ground of arrest has not been communicated by the IO in writing to the case. It is to be noted here that the accused, namely Abdul Khair Mohammed Siddiq, was arrested in connection with a special language case number 43 of 2023, arising under Karimganj case number 334 of 2023, under section 31C, 35, 29 NDPS Act. On the basis of one FIR lost by one SI Badruzaman Ahmed of Karimganj PS on 5/5/2023. The allegation against him was that the concerned IO on acting on a tip of on 5/5/2023 about 5:20 AM intercepted one Maruti Alto vehicle bearing registration number ES10 F0531, driven by the accused. And during search, the IO has recovered 48 soft cases containing 567 grams of suspected heroin. And during interrogation, the driver disclosed that one Abdullah Sodhuri alias Bablo was the receiver of the aforesaid consignment of contraband substances. Mr. Ahmed learned counsel for the accused, referring to Annexure A at page number 65, and also page number 62. The notice under section 50 is issued to the accused submits that nowhere in the aforesaid two documents the ground of arrest was communicated to the accused. And in view of the decision of Honorable Supreme Court in the case of Bihan Kumar, reported in 2025 SCC online SC 269 at page number, at paragraph number 14 and 15, and also the decision of Honorable Supreme Court in the case of Kabir Protester versus State Bhubaneswar and City Delhi, reported in 2024 8 SCC 254, especially the paragraph number 29, 30, and 31 submits that for non-compliance of the aforesaid requirement, the right of the accused is violated, and therefore it is contended to allow the petition. Has to be noted here that to appreciate the submission of learned counsel for the petitioner, the case diary, scanned copy of the case diary of called for from the Court of Learned Special Judge Dhuri.
Lordship Shivbhumi.
Shivbhumi.
Yes, Lordship.
And having gone for the same, Mr. Hosho learned additional PP submits that except page number
65 and 66.
65 and 66.
Yes, Lordship.
The memo of arrest and the notice under section 50, there is no other document to show that while causing arrest of the accused, the IO has complied with the aforementioned provision by communicating the grounds of arrest in writing to the accused. And Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record. And also heard the decision referred by Mr. Ahmed, learned counsel for the petitioner, and also gone to the case diary received from the learned trial court. And it appears that except page number 60 and 60.
65 and 66, my
65
lord.
and 66, there is no other document to show that the provision of section 50 of the CRPC is complied with while causing arrest of the accused at the time of arrest. And as such, the as such, the arrest of the accused appears to be illegal. In contrary to the provision of law and also the decision of Honorable Supreme Court in the case of Bihan Kumar and Pavirpur Castro. Under the aforesaid extant circumstances, this court is inclined to allow this petition. It is provided that on participation a bond of rupees 1 lakh with 1 security of like amount to the
My
satisfaction
lord,
of the
only my
parties.
one humble prayer before your lordship is this, as because my lord is a case of my lord commercial quantity. Some stringent condition may be there, my lord, so that trial may be completed, my lord.
Furnishing a bond of rupees 1 lakh with 1 security of like amount to the satisfaction of the learned trial court. The learned trial court will be at liberty to impose further condition to ensure presence of the accused during trial.
Item 50,
Same order.
So in my case, lordship, that notice will be at page 71 and 73.
Okay.
And one more aspect, lordship, may kindly refer to paragraph 21 of Bihan Kumar's case, because paragraph 21 says that it will, even if there is statutory restriction, that will override, it is Article 22 is violated. Because this is, their section 37 is there, therefore that.
Okay.
item number 32 upgraded. Parhat Mehta.
My lord, in this matter, my lord, my friend Mr. Jagannath Ghosh, has senior advocate, has come from Calcutta, who is dealing with intellectual property matters. He will assist your lordship in reply that few judgments, my lord, vis-a-vis the imperial.
I'll give my learned friend a copy, my lord, he can distribute. Yes.
I have concluded my submission.
Yes, we are from the same chamber. Between us, my lord, I'll give him a copy.
The matter is a matter which is the matter.
My lord,
So the main
my lord,
thing is
it's
that-
saying, my lord,
so
if
the
I
main-
cite a
But
judgment,
the
I'll
main
give
thing
him
is
a
that
copy.
when we reply, I think they cannot start a case afresh by citing,
no.
by citing
My
judgment.
learned friend has cited Kemco.
I will
Kemco
have to be rejoined there.
Yes, he's on that. It will be a reply, my lord.
Reply, only judgments, I'll give him a copy, because lordship will be laying down the law here, my lord.
There's
That
no
Kemco, my lord, kindly, my lord, what's the
There is
principle?
nothing
One by one.
Lordship.
It's a principle of natural justice, my lord. The issue is covered by a Guwahati judgment itself, my lord. This issue, different name, different getup. My lord, if I cite, I give my learned friend, lordship will give him a chance to distinguish. I do not need to, my lord, further rejoin, my lord. Again going, my lord. If I cite, he gets a chance to distinguish. We all do it in Calcutta, my lord. I have done other matters also. I leave it entirely to your lordship, because Kemco has been cited. Kemco has been dealt with in some other matters. My lord, the issue, my lord, of my lord, this, that.
Kemco have not cited.
My lord, the issue, my lord, the issue is, my lord, what? Names are different. Packets, my lord, are, my lord, color combination, which is weighing on the code. I could understand, my lord, my junior was on video. I could not come the last day, my lord. Now, the issue, whether, my lord, that itself, my lord, is a ground for granting ex parte injunction, my lord. That issue is covered by the Guwahati High Court
And
judgment.
I'm not on the name. That I made it clear on the first.
First, let him come.
My lord, if I cite anything, if lordship, normally we do, it's a point of law. Lordship will be laying down the law here. If I cite, give him a chance of, my lord, distinguishing. I don't need a sir rejoinder to that. My lord, may I, my lord, start?
Yes.
My lord, if your lordship, just I cite
just place the order, one paragraph of the plaint, and I straight go to the judgment. Now, my lord, kindly takes the note, there will be no re-hearing, my lord. I don't do it, my lord, of the matter, my lord, showing papers, my lord. My lord, kindly, it's an appeal from an ex parte order. Ex parte order. If I, my lord, have to impugn the order, Lord, I have to proceed on the basis of, my lord, the plaint, annexure, injunction application, and the annexure. I cannot travel beyond that. And I have to proceed on such basis. My lord, the order is dated 10th of January
No,
20.
you were only supposed to reply to the
Yes,
argument advanced by.
yes. Only on the ground.
Reopen the matter
no,
again.
No, not at all. I don't want. My lord, on the, my lord, 12-way aspect. My lord, for the purpose of 12-way aspect, my lord, lordship has to see, my lord, when is the knowledge and when is the order passed. That's all, my lord. Knowledge is, my lord, 19th June, according to, my lord, according to the petition case. Notice is, my lord, 19th of June 2024. My lord, ex parte order is 10th of January 2025. That's all. On that ground, my lord, the urgency has been waived because ex parte order, my lord, is an exception to the rule. Because Trademarks Act section 135 says, my lord, may, not shall.
Okay.
Now, my lord, if your lordship takes 12A of the Commercial Courts Act, if your lordship kindly takes, I'll not, my lord. Lordship has indicated I'll not do that. If your lordship takes on the point of law, the Commercial Courts Act, my lord, 2025. I think lordship has a copy, 12 capital A. Has lordship has a copy?
Yes.
Amar copy ta na. May I hand up my copy, my lord? May I hand up, my lord? Okay.
Yes, so we had it, but.
Kindly have a look at, my lord, 12 capital A. A suit which does not contemplate any urgent relief under this act shall not be instituted unless the plaintiff shall, not me, unless the plaintiff exhausts the remedy of pre-suit mediation in accordance with the manner as prescribed by the rules. So, my lord, this is a mandate of the act. It's a commercial dispute. Now, my lord, mediation period is 3 months. Mediation period under the act is 3 months. Now, if a plaintiff can wait for 3 months, couldn't he have, my lord, exhausted the remedy under 12A and come to the court? This is the first, my lord, because, my lord, admitted case, my lord, is the plaint contains by the notice of, my lord, 19th of June 2024, and, my lord, my reply, the defendant's reply of 27th of June 2024. And the order records his reply. There is a recording in the order. So this is a jurisdictional issue. The court should have, my lord, at least, my lord, decided that on 12A, that this is, despite that I am dispensing with. Now, my lord, kindly have a look at one judgment of, my lord, the division bench. Sir. May I hand up a copy, my lord? Very short, my lord. I'll try to, my lord, wind up, my lord, very quickly, my lord. Kindly have, this is a trademark matter. No. Eta ki? BS Sponge to diyecho. Oh, kindly have a look at BS Sponge to. My lord, kindly takes this first. Join Shanton ke copy dao. Kindly have a look at BS Sponge. My lord, I had the occasion to argue that, my lord, in a trademark matter, it's a recurring cause of action. So, my lord, delay does not, my lord, itself is a ground for refusing 12A in question. Now, lordship will kindly have a look at the judgment in question. Kindly have a look at, this is the judgment of really. My lord, kindly have a look at, this is an appeal arising from very short order, arising from an order passed by the learned single judge on 2nd August 2023 revoking leave under 12A of the Commercial Courts Act. The reasons revoking the leave was initially the plaintiff issued a cease and desist notice on 25th May 2021 and did not pursue the claim, and thereafter the claim has been filed in 2023. The word recently has been used in the order to show that in any event notice is served, the plaintiff will suffer irreparable loss. In first place, the plaintiff could have shown urgency in 2021 and claimed dispensation of 12A if there was a clear case of infringement and the plaintiff is the registered owner of the mark. Here, my lord, both parties are, my lord, registered owner of the mark. There are disclaimers in the mark. So it's a passing of action. Usually in a suit for infringement, ex parte order was passed on multiple principle of prejudice may be caused to the plaintiff in the event of any notice being served. However, having regard, this is most important. This was the law then. Now, after, my lord, enactment of the Commercial Courts Act. However, having regard to the amendment in the Commercial Courts Act, it is the discretion of the court as to whether the case has been made out for the dispensation under 12A, which is held to be mandatory. In party automation reported in such and such, it has noticed that tendency to bypass the said section should be stopped. Otherwise, the said section may be rendered ocious. Now, my lord, kindly have a look. The court is required to find out whether the averments in the plaint point to a situation. This is most important, my lord. I stress this part. My lord, the court is required to find out whether from averment in the plaint point to a situation that even before expiry of 3 months, the plaintiff may have the need to obtain urgent relief. Now, 11 notice is of June 2024 and the suit has been filed on 7th January 2025. And, my lord, ex parte order has been passed on 10th January 2025. My lord, I believe, my lord, it's more than 3 months. The window. If you can sit over your right for 3 months, you should have done mediation and come back. This is exactly saying. In the facts of the case, it appears from the impugned notice that the plaintiff did not proceed with the matter after cease and desist notice was further issued on 25th May 2021, and only thereafter on 26th April 20, the further cease and desist notice was issued to create any urgency. Here, my lord, there is a repeated correspondence between the parties from June to August, June to July. Admitted position, my lord, it's part of the plaint. I am not showing, my lord. My learned senior friend has already shown it. Thereafter, on a further cease and desist notice was issued to create urgency in the matter. Here, my lord, there is none. After July, my lord, there is a stoppage, and my lord, thereafter, my lord, the statement is, my lord, that, my lord, in hills of, my lord, this, my lord, northeastern part, my lord, the goods have been sold. There is no pleading that after the earlier cease and desist notice, the defendant has withdrawn the alleged infringing material. This is also not the case here. The fact that the learned single judge has taken into consideration in directing the parties to file a fresh suit if pre-mediation fails, we are not inclined to interfere the discretion exercised by the learned single judge. In this regard, the appeal is disposed of by confirming of the order of the single judge in any event application of mediation terms of such and such. So, my lord, I was on the receiving end. Let us put it without I was on the receiving end. My lord, if you can wait for 3 months, then could you, my lord, put an ex parte order? The suit is there. And section, my lord, 12A is a new scenario. It's a new domain, something which is in the new domain. Now, my lord, if something is waiting for, is in limbo, I say, my lord, in vacuum for 6 months, then, my lord, a suit is also, my lord, postponed for mediation. Then, my lord, in such situation, whether, my lord, the mandate as prescribed under Order 39, Rule 3A, my lord, could be, my lord, waived. That is, my lord, what? Dispensation, my lord, of service of notice to the defendant, my lord, prior to issuance of an order of injunction. Because lordship knows it is settled law, my lord, service of notice to the defendant prior to the injunction is a rule. Exception is, my lord, to pass an ex parte order of injunction. More so, when, my lord, this Commercial Courts Act has come into force. Further, my lord, lordship will see from the order itself. I am not showing the order since lordship has made it clear. The order records that there were notice and after notice, caveats have been filed in Calcutta. Why Calcutta? because the registered office of the defendant is in Kolkata, registered office of the plaintiff is in Kolkata, and the natural forum is in Kolkata. So caveats were in Kolkata. So Willard, in such scenario, whether it was any breach of Millard legal duty on the learned single judge with utmost of the district judge Millard with utmost Millard humility, I say Millard, to dispense with notice Millard as contemplated under Order 39, Rule 3. This is my first submission. The Lordship takes the next view Millard of Millard the division bench in question. Pranay Shah. Pranay আমাকে দে এটা তোমারই কথা Pranay Shah. Kindly, my lord, takes my lord Pranay Shah's case, the next judgment. I have given my learned friend a copy. This is at as late as 3rd March 2025. This is, of course, my lord, not a trademark matter. But, my lord, kindly look at the averments in question. Para 7, internal page 3. My lord, I am not reading the entirety, my lord. My lord, what has happened, my lord? There was an agreement for sale. In the meantime, I just say it orally, Vigilance Commission Millard had plaintiff's case was, look, Vigilance Commission is coming after me because I have not filed a suit. That's recorded in page 3 Millard, internal page 3 of the order. Initially, leave was obtained under para 7 if a lordship takes Millard. Initially, leave was obtained under 12A of the Commercial Courts Act. Subsequently, on an application filed by the respondent for revocation of the leave, the said application was allowed by the learned single judge. The plaint was rejected with an observation that the rejection would not preclude the plaintiff in instituting a suit as against the defendant on the self-same cause of action after complying with the institution mediation if otherwise permissible by the law. Mr. Such and such learned senior counsel appearing on behalf of the plaintiff submits that the learned single judge has failed to appreciate that the suit contempts urgent relief on the basis leave was granted. The application for revocation was filed on behalf of the defendant. It is submitted that even in the written statement, defendant has not evinced any intention to have the dispute resolved in mediation. So this was the argument. So if you want to go mediation, defendant should say that I have an intention to go to mediation. Drawing attention to the averments mentioned above, it is submitted that the said averment is sufficient for a leave under section 12A as contemplated and urgent relief. The learned counsel relying on referring Jamini Monhar reported in such and such, there is a Supreme Court case, has submitted that it has categorically held in the said decision that when a suit is filed with a prayer for urgent relief, it is the duty of the commercial court to find out whether the suit contempts any urgent relief or not. Unfortunately, my lord, there is no, my lord, finding on Millard, this discussion is not there. What he says, Millard, like a normal CPC suit, Millard, that if notice is served, Millard, the purpose of injunction will be defeated. But Millard, he doesn't take into account that a party who sits on his right for Millard 6 months, Millard, Millard should be relegated to mediation. But he goes one step further, he passes the ex parte order of injunction. Now, Millard, kindly Millard takes Millard, it is immaterial. It is immaterial whether any such relief would be granted ex parte or with notice or the said application might ultimately fail. But bona fides of the plaintiff in approaching court seeking leave under 12A would be the paramount consideration. Next, it is further submitted that the learned single judge has proceeded on the basis that the suit was filed near the period when limitation would be said to disregard the plaintiff to institute the suit within the period of limitation. The consideration for rejection of the plaint on the ground that the suit was filed close for the limitation is not a ground on which the leave under section 12A was revoked. So even, Millard, if I have 1 day, Millard, before limitation or a month for going, the suit would be barred. If the claim is also distinguished, 12A cannot be revoked. This is the high test, Millard, given Millard. Learned counsel appearing on behalf of the defendant of the respondent has submitted that by reasons of failure on the part of the plaintiff to perform the contract, defendant has suffered loss. Now, kindly Millard, take Millard. Kindly Millard takes Millard, paragraph 10 and 11, the next page. At this stage, we are not concerned with the defense of the defendant. So, Millard, what is Millard? I am not arguing. Normally, Millard, we learn, Millard, it's always a learning curve, Millard, for an advocate, Millard. That Millard appeal from an ex parte order, you have to show the order, show the plaint. Normally merits are not gone into. Sometimes the court Millard goes Millard to the merits. At this stage, we are not concerned with the defense of the defendant. The Honorable Supreme Court in Patil Automation reported in such and such has conclusively held 12A is mandatory. However, in exceptional circumstances, the court may dispense with such leave depending upon the frame of the suit and such relief sought. Now, next is most important. This is now holding the field, paragraph 10, 11 and 12 of Jamini Munah. Small window, falsity and deceit and delay. In Jamini Monohar Supra, while referring to the views of the Delhi High Court, it has been observed that the commercial court should examine the nature and subject matter of the suit, the cause of action. So this is most important. It doesn't end. So not only subject matter of the suit, the cause of action. If a cause of action, Millard, is Millard way beyond Millard 3 months, naturally, Millard, there is some problem. You have to go to mediation. For the prayer for urgent relief, subject matter of cause of action and the prayer for interim relief. The prayer for urgent relief should not be disguised or marks to wiggle out or get over 12A of the Commercial Courts Act. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Applying the aforesaid principles and trace, we are unable to accept the submission of Mr. Such and such. The frame of the suit contemplates urgent relief. That merely because it's an infringement or a passing of action or an intellectual property right, it automatically contemplates urgently. The contract was alleged to have been performed between such and such, the contract was terminated, etc. Now, Millard, next, Millard, paragraph 12, 3 lines from the bottom. The urgency pleaded in paragraph 43 for dispensation is a veiled attempt to circumvent 12A. The explanation offered is unacceptable. The complaint of the State Vigilance Commission West Bengal with regard to the alleged immoral practice carried out by the defendant in collusion of Kolkata Municipal Corporation Development Authority and the demand probe into the activities have no relevance to the cause of action pleaded by the plaintiff for recovery of the price of the goods sold and delivered. On consideration, paragraph 13, on consideration, we do not find any interface to interfere with the order passed by the honorable single judge. However, it open to plaintiff to refer to the dispute mediation and spend will be limitation, he will get it. So this is, Millard, the law on the subject. Now, Millard, kindly takes, Millard, the judgment of the Guwahati High Court on the merits of the matter. This is a jurisdictional High Court, Millard. Kindly have a look at the judgment in question. Millard, judgment is called Super Candle. Millard, I am Millard. I read it yesterday at the county there. Millard, this is Millard. Just after Millard, previously Lordship knows Millard in Morgan Stanley and Millard Shiv Kumar Chadha, courts Millard did not give reasons. Court did not consider urgency. Court Millard did not, Millard, there was no obligation. This was just after Millard. This is one of the first judgment after Morgan Stanley and Shiv Kumar Chadha. This is the judgment of this court, Millard. So I just, Millard, read the judgment, Millard. Kindly have a look at page number. This is a trademark matter. Page number 370. Look at the prayer of the plaintiff. Millard, page number is on the top, 1996, 3 Guwahati Law Journal, Millard. Page is on the, has Lordship found out? 370 is very small, Millard, written, Millard. Paragraph, Millard, it's Millard, part of after judgment and the order, a suit was filed. Kindly have a look at paragraph 3. Has Lordship found out? To grant ex parte ad interim injunction restraining the opposite parties in any way using distinctive get-up, design, and arrangement. So, Millard, case of get-up, arrangement, design of the petitioner's trademark, rocket and rocket device, and in any way passing of candles under the labels, having distinctive get-up, design, and arrangement of the petitioner's trademark, in particular, and restrain them not to sell it. Now, Millard, kindly take, Millard, paragraph 4. The Honorable District Judge's, Millard, order. On perusal of the plaint, I just place it because on the touchstone this order has been. On perusal of the plaint annexed to the document and on consideration of the submission of the learned counsel for the plaintiffs, I am satisfied that the plaintiffs have made out a prima facie case to go to the trial. I am also satisfied that the entire circumstances the plaintiff's prayer for ex parte ad interim injunction also needs to be considered without giving notice of application to the defendants so as to protect the interest of the plaintiff. Same as our case will. I agree with the submission of the learned counsel of the plaintiff that unless ad interim order is granted, the plaintiff would be put to a serious loss on account of marketing and other products under a trademark deceptively similar to that of the
Mr.
plaintiff.
Counselor, in view of the decision of Supreme Court in the case of Morgan Stanley,
Yes.
so whether this decision has any relevance today?
Yes, yes. Yes, this follows Morgan Stanley.
You are relying upon the Morgan Stanley also.
No, Lordship will take this. It relies Morgan Stanley. It's a trade. Morgan Stanley is not a trademark matter. This is a trademark matter. This follows Morgan Stanley. Kindly, Millard, take Millard. I try to shorten up Millard. Millard kindly takes Millard. It follows an earlier Guwahati judgment, paragraph 21. Paragraph 6, Millard, reasons to be recorded in writing. Millard, I know Millard. I am just kindly Millard takes Millard. Paragraph page 282, 382, para 14 of an earlier division bench is quoted. 382, Millard, it's paragraph 14, Millard, just below that 25. It follows Morgan Stanley. It follows Shiv Kumar Chadha. My junior is correct. If your Lordship takes Millard 382, Placitum B, Morgan Stanley is quoted. Morgan Stanley versus Kartik Das. Lordship has found it. So, Millard, it follows. Millard, the principle quoted above would show nothing has been said in the paragraph that delay would defeat injunction. This is a finding which should be must. Delay would defeat injunction. Power to grant injunction is a tremendous one, and it should not be exercised hastily or without solid reasons. An injunction with previous notice to the affected party is a deviation from the ordinary course of justice, and same should not be resorted to without strong and grave reason. Rule notice must be given. Unless the matter is urgent, injunction would be defeated or irreparable mischief would be caused to the delay. While a consideration of injunction ex parte, court should not act casually and in a caviar fashion, but pass an order only after adverting to all the facts of the case. The provision for issuance of notice to the opposite party without granting temporary injunction is mandatory, and the court has been given the power to dispose of the notice when it comes to the finding granted defeated by delay. So if there is already a delay of 6 months, Millard, the finding of learned single judge Millard of the Millard trial court Millard, that Millard, if notice is given, Millard, plaintiff would suffer with deepest of respect, with utmost humility, I say, it's perverse. In view of the judgment of the jurisdictional high court. Case may be imminent danger that if this being disposed, he has given the example of dispossessed of the property. There may be cases. There may be numerous such cases that the court must find whether the case deserves to issue an injunction with notice to the other party. Now, Millard, if the order itself records, there is a notice of Millard June 2024. Millard, is it an exercise of a discretion on proper principle of? Now, Millard, kindly Millard takes Millard. This is Millard. I don't want to serve it, Millard, or read it again. Then Millard, Aparajita Mukherjee, another division bench is quoted, another matter is quoted. Now, Millard, trademark is given, Millard. The definition of mark 28. Has Lordship found out 28? It's page number 383.
Yes.
Mark includes device, brand, label, heading, ticketing, name, signature, word, letter, or numerical, or any combination thereof. So this is the definition of mark. Old. Now, Millard, under the new act, there is one addition: color or combination of colors, not a single color. Combination of colors. The new act adds a phrase combination of colors. This is the additional comes in the 1999 act. Now, Millard, if 2 marks are registered, like the case, it's a passing of action. Lordship will kindly omit that. Now, Millard, kindly take Millard. Paragraph 35. I am just skipping Millard since Lordship has indicated 386. Paragraph 35. In the present case in hand, there is no question of phonetic similarity, as one is Prince Fighter and the other is Rocket. Here, my lord, Arham and swastik with a, my lord, greenish label with a black such and such. Whether it's itself an prima facie case to grant an injunction when the names are different. This brings into existence of two different kinds of goods because, my lord, fighter is one thing, rocket is other thing. Here, my lord, swastik is a Hindu device and, my lord, Arham is a Jainism, my lord, symbol or device. When an ordinary customer will go to the market, there is no question of confusion as much as they will ask for the brand of two different goods, one for Prince Fighter and other for Rocket. The trademark is undoubtedly a visual device. Next paragraph, it is well established law that essential feature not only by ocular test alone, since the word can form a part or whole part of it, is bound to cause consideration of sound or pronouncement of the word. The word used in the instant case are absolutely different from the two possibility of deception as a possible to go purchase of two different goods in two different names. Actual resemblance of the mark is not the sole concern, manufacture the two names used. Now, Lordship will omit that. Lordship will straight away come to paragraph 45. Placitum G. That's the last page of the judgment, 392. Paragraph 45, Placitum D. There may be some exceptional cases where the action of the defendant may be dishonest. Now, Lordship will kindly bear in mind that, my lord, it's dishonesty pleaded, but there was a notice, there's a reply. In the plaint case, paragraph 3, the user claim is, my lord, by, my lord, the plaintiff is 2001. In the notice, my lord, which responds to the notice, my lord, reply has been given on 27 June 2020, my lord, 4. It has been alleged and stated the defendant is using from 1998. So, my lord, the defendant has raised a claim of prior user. Now, in this type of matters, normally who is a prior user is a question for fact. On the basis of plaintiff's own assertion cannot be done. So that has been ignored by the trial court. Despite, my lord, those notices were part of the record of before the trial court. There must be some, in cases, defendant may be dishonest or otherwise in all cases, courts may adopt a path of caution and avoid grant of injunction on mere asking. Next, in the instant case, I find a discretion, the discretion by the court below is improper, unreasonable, capricious, and not proper exercise of discretion in a suit for infringement of the trademark. Best method is to compare the two marks and come to a tentative finding of general similarity, which may be possible to unaware customer. He has gone for a finding, but he says that I don't go on the merits. My lord, can it be done? In Bengali, my lord, if your lordship, my lord, conversant, my lord, its, my lord, says sonar pathor bati, means a, my lord, cup which is, my lord, said to be of, my lord, stone, but is actually made of, my lord, gold. So if you say that, my lord, if you say that I am not venturing into the merits, then how you have considered the label? That's a finding. I am not going in the merits of the matter. Then if you don't go in the merits of the matter, can the court say, my lord, there is a prima facie case? I'll just show two paragraphs of the order. My lord, this is, my lord, kindly, my lord, it's a method to compare the two marks, tentative and all probably unknown, and the order was set aside. Now, my lord, on the, my lord, packet itself, kindly have a look at the Delhi High Court. Britannia, my lord, was doing, my lord, a business of biscuits. Lordship knows NutriBites Britannia. My lord, both Britannia was blue and yellow and green, and my lord, ITC was blue and yellow. Now, my lord, Britannia, ITC filed a suit against Britannia. The names were different. One was Zero Sugar and one was NutriChoice. My lord, kindly have a look. This is a Delhi Division Bench. My lord, kindly have a look at it. This is reported in 2017 SCC Online, Delhi 7391. Only one paragraph I show. Kindly have a look at the Delhi Division Bench. This is 2017, it's a division bench.
Page number?
My lord, kindly have a look at, just, my lord, I just want to give only one para, so just give me 1 minute, my lord. Para 19, if your lordship takes, my lord. Just above, my lord, paragraph 19. The issue here, Millard, kindly test the case, Millard, on uncontroverted, Millard, facts, Millard. There is a plaint. I don't have an affidavit in opposition. There is a assertion by the plaintiff user from 2001. There is a response to cease and desist notice user from 1998. Kindly take, Millard. The issue here, just above paragraph 19, the issue here is in case of passing off is not only new biscuit or new product has acquired popularity in this sort, but whether the get-up and in particular color combination of yellow and blue has been exclusively identified with the plaintiff's products. In the other words, combination of yellow and blue has become clear and established a source identifier. I may pause here. May I say two sentences, Millard? Millard, if you think of closing one size, battery with red, one can think, Millard, it's Everett. This is, Millard, the test. Millard, something purple, Millard, which is a chocolate, it's Cadbury. Now, Millard, something with, Millard, chocolate with red and something, Millard, written over the top, Millard, it's Kit Kat. Now, Millard, coconut oil parachute, if we close our eyes, blue bottle means a parachute oil of coconut. Like, is it that case here? It's all color identification. Like, Millard, batteries, I say, Millard, red batteries are, Millard, connected, Millard, to Everett. Let us, Millard, purple color, Cadbury. Kit Kat, red. Millard, kindly take. The learned single judge felt Britannia has been late in introducing zero digestive biscuit, paragraph 9, till 6 months after ITC introduced the products, and accordingly learned single judge was a factor for weighing in favor of identity. We do not think this could be a factor. Ultimately, it has to be seen whether the combination of yellow and blue has attained distinction amongst the public, being exclusive related to the product of the plaintiff. Now, Millard, kindly takes, Millard, paragraph, Millard, 21. Or, Millard, 20. And I, Millard, go to the straight away the other one. Furthermore, the learned single judge has quoted Carly in paragraph 30 of the impugned order. The said passage itself makes it clear that if the claimant by caution and advertisement shows that really on mainly his trademark business name makes the case general get up from the trademark or business name more difficult to be established. So one is ITC, zero biscuit, one is neutralite. So if you go by the get up like blue, yellow, red, yellow, fully green, fully, then it is more difficult to be established. That is not a prima facie case. Because the names of the products are different. Then very tall, high case, like the Excite batteries, it's red. Now, Millard, kindly take, Millard. In the present case, ITC mainly relies on a trademark and business. That being the case, ITC would in any event have a greater difficulty in establishing the claim based on general get-up and in present on combination of blue and yellow and blue. Paragraph 20. Now, Millard, kindly take 21. Millard, 4 lines from the bottom. We do not think that in short span of time, particular Vetile has alleged to have the first invoice of 2016. Here the invoices are not of 1998. Bare invoices given of 2013. My claim is from 1998. The yellow-blue combination of the packaging of the ITC's biscuit has become so identified with ISMS to enable ITC to prevent use by the combination. So by the color combination itself, when the name are different, so it should be so distinctive. By seeing blue and yellow, people will only think it's ITC's biscuits. Now, Lordship will kindly take, Millard. This is all Millard. Millard, kindly have a look at the next, Millard. Paragraph 23, Lordship will come to internal page 14, just one line. Court says that there cannot be any monopoly in relation to a primary color, because Lordship knows, Millard, there are 7 primary colors. It's called Viv gear. Now, Millard, if your Lordship takes, Millard, the paragraphs in question, Millard, top portion of paragraph 14.
Yes.
It is true, Millard, that's Millard, 8 lines from the top. It is true that the intention is not necessary for demonstrating the second element of passing off, that is misrepresentation. But it is also a factor which is need to be taken into consideration. This is also because Britannia has been using yellow as its primary color in combination with red and green on the earlier products. Therefore, in the natural evolution of combination of yellow and blue for digestive zero product, and quite understandable. We are making this comment because the observation of the learned judge to the effect that even if we had accepted that yellow as a color was integral of Britannia's packaging of the scheme of digestive biscuits, that if I have made a change, it's not a case here. The Britannia's purpose could well be served by adopting the color other than blue to combine with yellow in its packaging. The question, however, remains, why should Britannia be required to adopt a color other than blue? It is asked to do so only if ITC has established the get-up from the yellow to the combination has become so distinctive of the product that any person who saw yellow-blue combination on his packaging of digestive biscuit, he would associate it with ITC, but this has not been established prima facie. Now, this is without any affidavit. How can it be done? It's only because you are in green packet with some black in it. Does it itself give you a cause of action in passing off? When the marks in question are Aram and swastik, is it phonetically similar? Is it visually similar? Now, merely color is there. That is not a weighing factor. Now, Millard, kindly, more or less I have concluded. Now, Millard, kindly have a look at just one judgment. Millard, admitted position.
Time is almost over.
Yes. Millard, I have concluded. Millard, this is not a rule. This is an exception to the rule, Millard. That ex parte order, that is a Supreme Court to such effect. And Millard, courts have been cautioned, Millard. If your Lordship, Millard, takes, I just indicate the paragraph. 2011-8. Kindly have a look at it. আমার এখানে আছে। Kindly have a look at one paragraph. Para 38-265. Unique energy.
Yes.
The courts have to be extremely careful in granting an ad interim ex parte injunction if injunction has been granted on the basis of the false pleading. So what is the pleading? That Millard, there is the goods have Millard, basically Millard escalated in the market. So in Millard thereafter, there is no specific date. Kindly Millard takes on forged document, court should impose cost. This must be done to discourage dishonest. Now Millard, kindly have a look at para 44. That's Millard, kindly takes para 44. Usually, Millard, kindly test it with the facts and circumstances of this case. Usually, the court should be cautious and extremely careful while granting ex parte ad interim injunction. Because why I say is because my learned friend was on caveat in Kolkata. Better course for the court is to give a short notice in some short case, even a dusty notice, before both the parties and then pass a suitable bipartite order. Experience reveal that ex parte injunction orders in some case can create havoc, and getting them vacated or modified in a judicial system is a nightmare. Therefore, as a rule, the court should grant injunction or stay order only after hearing the defendants and the respondent, and in case the court has to grant ex parte in exceptional cases, then while granting injunction, it must record that the order, if this should eventually dismissed, the plaintiff or the petitioner will have to pay full restitution in actual realistic cost. If an ex parte injunction is granted, then in that case, an endeavor should be made to dispose of the application as expeditiously as possible. Now, Millard kindly takes para 46. Millard, this is Millard all says to delay, etc., etc. So, Millard, this is Millard Supreme Court in question. Now, Millard, no. Kindly look at Millard the order in question, the impugned order. হয়ে গেছে ছেড়ে দাও আর দেখিয়ে দাও হ্যাঁ সেটা দেখিয়ে দিচ্ছি kindly have a look at the order in question. Has Lordship got an order in order Millard impugned order? It's Kindly have a look at the order. Just cryptic, my lord, I show. My lord, kindly have a look at page number 4 of the order.
Page 24 of the stay application.
Page 24 of the stay application of Lordship is looking at the memo, my lord, which the order is filed separately, my lord. Lordship internal page 4 of the order in question.
Yes.
In June 2024, the petitioner received complaints about poor quality of rice sold under the similar trade dress featuring swastik symbol, misleading the customer in a way from the petitioner. The investigation revealed that the impugned quality of rice branded as Joy Baba
You
is
are
being
reading
sold
paragraph
using.
number? You are
My lord,
reading
kindly
paragraph
take, my lord, it's internal paragraph 6. It continues to paragraph page number 4 bottom. I'm not reading the entirety.
Yes. Yes.
Second last line. In June 2024, petitioner received complaint and came to the knowledge, as Lordship found out from the intern. Millard, paragraph 6, Millard, starts at page 3. It rolls over to page 4 of the internal page of the impugned order. Stated that or not?
Here is page 27.
Stay is page 27 of the stay application.
Yes.
In June 2024, the petitioner complains about poor quality rice sold under the trademark similar featuring the swastik symbol, misleading the company investor revealed that the inferior was being sold by Joy Baba using a design closely resembles the plaintiff's registered trademark. And there it was written, Millard 100% pure. Now, Millard, anyone can write 100% pure. Now, Millard, Sotex BPT rice is a quality of the rice where the rice is polished in a Sotex machine that is written in the packaging. On June, Millard, the learned judge Millard himself records. Millard, on June 19, 2024, the petitioner issued notice to opposite party number 1, which denied the claims and files caveats in Kolkata. So, Millard, if I am in caveat in Kolkata, Millard, was it the Millard obligation of the learned single judge of the Millard trial court, Millard, to issue a notice prior to passing in Kolkata? Because Millard, there's a bypass of it's been bypassed. Parties are from Kolkata. This is Millard, parties are from Kolkata. Registered office are from Kolkata. And they, Millard, I am not citing, but Lordship knows there's a judgment of Sanjay Dalia which says in the civil procedure code, Millard, if the parties, Millard, registered office are for the parties which are relevant in a trademark matter. Not is, Millard, branch office or ancillary office. Registered office, that's Sanjay Dalia. Plain says that, Millard, I am in Kolkata, the plaintiff is in Kolkata. Just pull it down. Kindly look at the order. So, Millard, he notes that there is a caveat. If you note there is a caveat, I could have understood it's a suppression. Millard, my learned friend, didn't Millard tell the court it's a caveat, I have to go back and Millard raise. But if you are told there's a caveat in Kolkata and the party whose registered office is in Kolkata, it suddenly comes to Guwahati, Millard, to obviate, Millard, to bypass the caveat, Millard. Millard, wasn't proper for him. He can entertain it, Millard, of course, under section 9 of the Millard Code of Civil Procedure. But Millard, can he, Millard, dispense with Millard the service of notice? Or Millard, doing so, Millard, makes the order, Millard, I say, Millard, with lot of hesitation, vulnerable in appeal. Market on rice on the big basket. Now, Millard, kindly, Millard, now Millard takes paragraph 7. 3 fundamental principles, then paragraph 8. At this stage, without addressing the merits of the case, the court has carefully.
Mr. Counsel, on the other day.
Yes, if he has placed it, I am not saying. No. If he has placed it, I am not saying.
The matter.
Yes. If he has said this point, I am not saying this.
You are not supposed to reopen the matter.
No. I am not. I am not. Well, if your lordship takes Millard, now it's Sanjay Dalia. Millard, if both parties are in Millard, Kolkata having their registered office, It's on the trademark act, on the commercial law. Millard, kindly take Millard.
Dahlia says, Millard, commercial place of business, it doesn't
No,
say
no, no.
registered. office.
It says Millard Principal Office. Lordship, kindly have a look at it. Millard, kindly look at. It says Millard under section 20 of the Code of Civil Procedure. Lordship will find if Lordship takes the Code of Civil Procedure section 20 down. It says the principal place of business. For a company, principal place of business is its register office. Parata barcode 22. 22. And kindly have a look at the CPC if your Lordship takes Millard for the purpose of, because there is a provision to section 20, section 20 explanation. Has Lordship has a copy of the Code of Civil Procedure?
Yes.
A corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arising where the place it has been a subordinate office at such place. So this is the exception. Now, Millard, Trademarks Act say, Millard, it has to be filed in the principal place. That has been construed by Sanjay Dalia, the Supreme Court judgment. Paragraph 22, Millard, in no uncertain terms, Millard, says so, Millard. If your Lordship takes paragraph 22 of Sanjay Dalia, I'm not placing it, Millard. Millard kindly takes, Millard, paragraph 22 of the Sanjay Dalia and paragraph 24. It's absolutely clear. So, Millard, Delhi High Court, Millard, whose registered office are not in Delhi, Millard, are returning the plaint. Millard, I have folded it, Millard, for my convenience. Millard. Kindly have a look at paragraph 20. This is Sanjay Dalia, Millard, a Supreme Court of Millard, 2 benches, Millard. 1510 SCC 161. Lordship can note of it. Paragraph 20, 21, 134 of the Trademarks Act, 22 and 24. So, Millard, if someone has a registered office in Kolkata, if it's a natural forum and the caveats have been filed there, Millard, could that have been, Millard, bypassed and Millard, the proceedings been filed in Guwahati on the basis of a subordinate office? Millard, that's clarified in paragraph 24 and Millard, paragraph 25. So, Millard, this is Millard. So, Millard, these are the 2 points, Wellway and Millard territorial jurisdiction. Millard, this Millard cannot be Millard bypassed Millard in the rigors in this manner, particularly Millard when there's a caveat on board. And Order 39, Rule 3, my learned senior has argued, I am not going to argue. These are my respectful submission. Lordship has heard, Lordship has passed an order of stay. Of course, Millard, the coordinate bench must have seen, Millard, there is something, Millard, which is, Millard, lacuna in the order, so it stayed. Normally, courts do not stay, Millard, an ad interim order of injunction. Normally, it's a case of remand. And Millard, I have got packages. Everyone uses this package. Blue, red, green. It's their package, blue, green, and yellow. Where is the Millard? Where is the question of monopoly on green? It's a principal color, primary color. Only because I have used a green with a different name, there's a passing off. My user is from 1998. These are my respectful submission, Millard. That's all, Millard. I have concluded.
Yes. Both the parties are represented by their engaged counsel. Argument concluded. Anything?
The judgments.
Which judgment?
My lord, only thing, my lord, my learned fellow said that we have not filed Order 39, Rule 4 for objection there. My lord, our High Court full bench judgment is there. My lord, that the appeal is maintainable against.
I'm not saying the appeal is not maintainable.
Very good.
Of course, I'm not saying. I've said something different. I'm saying yes, in spite of filing an Order 39 Rule 4, asking for not an Order 39 Rule 4, a section 151 for recalling, you take only one of the points of Order 39 Rule 3, you leave aside everything, you keep the recalling pending, you don't take the points of the jurisdiction, you don't take the points on merit, and you come up in appeal against an order of 30th, which is not the order of the 10th.
No. Both orders are challenged.
Please, Mr. Ghosh, don't see it and say that.
I'm saying it.
No, it's not.
I do not know what my learned.
It's only the order against of the order of 10.
No.
The appeal.
Bullshit. Both, sir, kindly take the memo of appeal, Millard. This is also, Millard, decided in the Guwahati judgment, Millard. That subsequent order need not. Calcutta view is, Millard, subsequent orders have to be challenged.
No,
Guwahati,
not on that. I am on that the 30th order records that the 21st order, that it will be continued. They keep the recalling application under 151 pending. And thereafter, they come up in appeal against the order of the 10th, which have been challenged in the recalling application by way of which has not been considered or rejected. No, the application has not been rejected. The order has not been given by the 30th order.
Miller, page 249 is the stay application where the order of 30th is there.
Stay doesn't
Miller,
come.
kindly, Miller,
See the memo. of
Miller,
appeal.
stay application is there on the memo of appeal itself, Miller. Kindly take page 239 of the stay order and also take and paragraph 39 of the memo. Kindly take that.
Okay, we'll
Both
see.
the orders have been challenged
Malas,
and
the memo
Guwahati
at
case.
page 2, being aggrieved and dissatisfied with the order dated 10th January 2025, there is no mention of 30th.
He will not see the other grounds, paragraph 39.
Grounds is something different. You have to challenge it specifically.
Basic order.
Take it as a ground
Yes.
because of the 30th, and you don't challenge the 30th order.
30th order
then it
has been
doesn't
challenged.
come.
It is challenged. Miller, subsequent extension need not be challenged. If
Now,
lordship
Mallad,
wants,
the
I can give that.
judgments, Mallad, my learned friend Mallad, in reply has cited Mallad 8 or 9 judgments. Mallad, I'll take 10 minutes.
No, time is already over.
I know. 10 minutes I'll take, or I can include it in my notes of argument and finish
You
it.
can.
I'll do.
Place it in the notes. of-
Grateful.
I'll do.
I leave it.
I'll
If
do.
you want
I'll
to
do.
reply,
I'll
then
do.
reply.
Argument
No, don't.
order is there.
I'll do. Well, and one thing I should clarify. It's not green and swastik. I have said that on when I was submitting. It is the overall arrangement of the factors in the mark, in the label. I have no objection. They carry on swastik, they carry on, but the overall arrangement.
You please furnish
Yes,
the
there's
text
two
to
bags I should give you a lordship, which I had.
to the court first.
Miller, this is ওর ব্যাগটা দাও। Miller, he doesn't sell
I'm
only
giving
in
mine
this
also.
bag. দাও না স্যার, আমি কি বারণ করেছি তোমায় কোনোদিন? আমি করতে পারি। তুমি তো দিচ্ছ বাবা।
আমি তোমার এটা
Kindly take the bag.
Well, he wants to bring in something which is not the cause of action of the suit.
Kindly take Miller. Arham has Miller, I did not. This is Arham.
Now they change it. Well, your lordship.
আচ্ছা তোমার দাদা আমার
Excellent. Excellent. Now your lordship sees.
এটা
They
তোমার।
want, I am showing mine. I have given mine.
He has yellow also. He says green is his. Then Miller, there is no exclusivity of green. The
Well,
case
I
falls.
can use, the plaintiff can use hundreds of colors.
Huh?
The defendant cannot use the color which has been used by the plaintiff all through since 2001.
Only color Miller can't be done. That's all.
Well, I'm on the arrangement, I'm not on the color, swastika or anything. And all of the registration that they are saying, I've also told it to your lordship, but I'm not on swastika.
We are only on expa. I'm only on his plate and the order. Nothing else.
Under number 51, under order 41.
Grateful to your lordship.
Pardon, Major.
Grateful for your presence.
Item 51.
Grateful to your lordship.
May please.
Time is almost over.
Yes, my lord.
Should we proceed to hear the
Because your lordship has fixed today in view of the fact that tomorrow is the date in the.
Time does not permit, then what to do?
So maybe taken up tomorrow, top of the list, my
Mr.
lord.
Proceed.
I have no difficulty, my lord. Tomorrow or day after tomorrow, my lord.
No, but tomorrow is the date. In view of that, your lordship has fixed today. So
Then
today
send it
there
by
is no
learned
time.
Advocates of both the parties, we assess and raise the matter tomorrow.
At top of the list, my lord.
Not at the top of the list.
33.
Well, 52, item
Yes,
number
yes, yes.
52. This item was also fixed for orders today because hearing was almost complete. Both sides were heard. They wanted to file some objection. They filed an affidavit yesterday, other side.
Yes.
So this has come on record.
So far we are concerned, we have already made the submissions, Lordship has taken, they have also argued the points. Only same points they are repeated, they have repeated in writing in the affidavit. That is there. So far I am concerned, I think going by their affidavit, the same points which have been already placed by them were taken note of by this honorable court. There remains nothing except passing an order by your lordship, going through those points. And if they want to say anything more on that, I think 2-3 lines, if whatever they want to say, I may not have to reply to that, because what I find prima facie, what they are saying is, I have already submitted reply also against that.
Lordship, my submission would be Lordship will take up this matter upon Friday at 2 PM, your Lordship. Friday at 2 PM.
Okay.
Friday at 2 PM.
Friday at 2 p.m.
Lordship.
Well, my junior has some problem on Friday. He will be out of station.
If possible, tomorrow at any time, my lord, in the second half.
At 2 PM, my lord.
Tomorrow we can try, Lordship, but there's some difficulty on our part, Lordship.
Fix it.
Lots of fix.
We'll try.
Lots of fixed matters, that two matters already fixed, your Lordship. This should be deferred.
Well, that will always remain, but we will have to accommodate. This is also a matter which was already heard by your lordship, needs to be disposed of. Because otherwise, as the lordship has heard the judgment read out, it will be a nightmare for me to get an order from this honorable court if this way they continue. Having argued their case, they wanted to file something, and then lordship allowed them, fine. But they should also accommodate.
My submission will be Friday at 2 PM, Lordship. Because it's our part to submit, Lordship, we'll submit our part and Lordship will close it forward. Okay.
Friday, firstly, my friend will not be there. Secondly, motion day, so many miscellaneous matters. Tomorrow is a hearing day, there will be less number of matters on the board.
Okay, try it tomorrow then.
Yes.
Tomorrow already there are 2 matters.
Fixed at 2, Lordship. That is why we made this
That's
submission.
why tomorrow lot of matters. are
That is why we requested our, we learned it senior.
All lot-
Already discussed about it.
Can you argue the matter in the morning hours?
Yes.
No, already that.
That is fixed at 2 p.m.
That
as
is why-
submitted by you.
No, Lordship.
2 matters, there's 8 are Lordship in the morning.
There's Radha cases are there.
In the morning.
Senior counsel is there.
Lordship.
In fact, Friday I am also not available. Senior counsel said that.
On the
we'll
same
argue-
ground,
Lordship,
Raja also
that is-
they took time.
In fact,
That is our point, Lordship.
So Friday I was also not available, but senior counsel said that we will argue.
Argue because Lordship is unfair on our part.
Mr. Monto, you are not supposed to answer anything.
Lordship.
I think so, my lord, I leave it
Yes.
to your lordship. But then, unless they come forward and say what they want to say, how long the matter will remain pending?
Friday at 2 PM, Lordship. We'll argue.
Why not tomorrow morning, they
Finish it.
can come and make submissions.
Finish our Friday at 2.
Try it tomorrow then. Yes. Morning.
Lordship,
Yes.
almost impossible, Lordship. Let us not make promises, Lordship. We can't keep, Lordship. That is why, Lordship, Friday. at 2 PM. Tomorrow will be okay.
No.
No, if a lot of cases have been fixed on Friday, then it will be difficult.
At 2 PM, Lordship. That is why fixed time, Lordship. We'll try at 2 PM. We'll
2
finish
PM
our-
also, there will be cases enough. Tomorrow at least, they can manage it, I suppose. I had a talk with their senior counsel, Mr. Sodri.
Yes.
He also told me that he has cases tomorrow. I said that somehow manage few minutes tomorrow.
Okay.
Because the same problem on.
He's not being, tomorrow he will not be able to manage. That is a discussion we.
Friday at 12 then, Lordship. Friday at
No,
12.
no. Mr. Monto has discussed the matter with Sotori.
Yes, Lordship. When he has told that tomorrow it will be very
It's
difficult,
difficult,
that's why Friday has been
Lordship.
agreed upon. That is the thing which has been agreed
That's why,
upon. and-
that is why Lordship on
Friday has been agreed upon.
Okay, let us do one thing.
Yes.
Friday at 10:30.
Lordship.
Yes.
10:30.
Yes.
Lordship.
This is the matter as top of the list item at 10:30
Lordship.
AM. Sorry. Rest of the matters obtained.
Item 36 and 38. Item number 30, which your lordship was hearing, but the interim order was still the next date of hearing. Lordship will kindly extend the interim order till it is.
Interim order personal yourself. Okay.
Thank you.